ಯಾರು ಯಾರಿದ್ದಾರೆ ಅದರ್ ಸೈಡ್? ನಾವು ಅದರ್ ಸೈಡ್ ಇಲ್ಲ, ನೋ ಅಬ್ಜೆಕ್ಷನ್ ಹೇಳಿಲ್ಲ ಅಂದ್ರೆ ಅರ್ಜೆಂಟ್ ಮಾಡಲ್ಲ. ಅಲ್ಲ ಹೇಳಿದ್ದೀರಾ ಸರಿ, ತೊಂದರೆ ಇಲ್ಲ. The policy of this court is that other side has to be here and say no objection. ಏನು ತೊಂದರೆ ಇಲ್ಲ ಸರ್, ಮ್ಯಾಟರ್ ರೀಚ್ ಆದಾಗ ಅರ್ಜೆಂಟ್ ಮಾಡೋಣ, ಇವಾಗ ಮಾಡಕ್ ಆಗೋದಿಲ್ಲ ಅಷ್ಟೇ. ವಿಲ್ ನೋಟ್ ಇಟ್ ಡೌನ್, ವಿಲ್ ಅರ್ಜೆಂಟ್ ದಿ ಮ್ಯಾಟರ್ ರೀಚಸ್. ಆಲ್ ರೈಟ್, ಎಸ್. You have to move it online. You have to move the memo online in this court. Please move it online. At your instance, the matter has to be taken up for hearing on IA. It will come in the normal course. How can you say you are still an impleading applicant? Ask the learned counsel for the petitioner to move it. Yes. ಅದೇ ಸೇಮ್ ಅದರ್ ಸೈಡ್ ಇಲ್ಲ ಅಂತಂದ್ರೆ ಅರ್ಜೆಂಟ್ ಮಾಡಲ್ಲ. We will note it down, we will adjourn it in the matter. Yes. Petition in this case, if we order dated keeping my name from the revenue record without conducting a proper inquiry, without issuing a notice to me. Therefore, I have filed this. Agreed of the order dated? Order ಯಾವ ಅಕ್ಷರ? Order passed by the Tahsildar. How can you challenge an order before this court? Order with Tahsildar. Correct, sir. Sir, there is an appeal provision. How can you maintain the writ petition? Go before the assistant commissioner. The provision itself is there, sir. What liberty? ಅದಕ್ಕೆ no. Liberty Allah. You can go and file. You file an application for condonation of delay. Let them consider. Learned AGA takes notice for response number 1 to 3. Notice to the other respondents is not necessary for the following reasons. Next para. Learned AGA raises a preliminary objection that the order impugned in this writ petition is passed by the Tahsildar Anekal Taluk. Stop. Learned AGA submits that there is an alternative efficacious remedy available to the petitioner in the form of section 136(2) of the Karnataka Land Revenue Act of 1964. And therefore, the writ petition cannot be maintained. Stop. Next para. Upholding the objections raised by the learned AGA, the writ petition stands dismissed, while directing the petitioner to approach the assistant commissioner in terms of section 136(2) of the Act, ordered accordingly.
That's of this point number 2. Point number 2, died at 2020 October. So they have not made parties.
Point number 2, Abdul Rashid.
After passing the order by the land group.
ಮತ್ತೆ ಚಿನ್ನಪ್ಪನ ಪಾರ್ಟಿ ಮಾಡಿದ್ದೀರಾ? ಅಲ್ಲೇ ಲೀಗಲ್ ಏರ್ಸ್ ತಂದಿದ್ರಾ? Abdul Rashid. ಹೌದು. But you have shown Chinnappa. ಏನಿದು? What is this? Please compare cost title. To Abdul Rashid, son of Sheikh Mastan Saab, so and so, Chikbalapura Taluk. Chinnapaya, son of Venkataramanappa. ಏನದು? Is who died? ಅವ್ರನ್ನ 3 ಅಂತ ತೋರಿಸಿದ್ರ ಇಲ್ಲಿ. ಅಲ್ಲೇ ಇದು ಟ್ರೈಬ್ಯುನಲ್ ಆರ್ಡರ್ ಅಲ್ಲಿ ಆತರ ಇದೆಯಾ? ಆತರ ಇದೆಯಾ? ಹಾ. So his submission is that Mr. Abdul Rashid is no more. Yes. You have not filed an application. You have not filed a memo. ನೀವೇ ಫೈಲ್ ಮಾಡಿದ್ದೀರಾ? ಯಾವಾಗ ಮಾಡಿದ್ರಿ? It is not come up. It has not been put up. Huh? Learn a council. Sri Anjanaya AP. B for Bangalore. AB. Submits that respond number 2. Sri Abdul Rashid. ಆ ಸ್ಪೆಲ್ಲಿಂಗ್ ಸರಿ ಇಲ್ಲ. Abdul is no more. And therefore, applications have been filed in the office on 9/1/2023 or 24 to bring the legal representatives on record. Full stop. Next para. Office is directed to put up the application. Stop. Release this matter on 7th of February.
Purchased by the late grandfather of Krishna.
Next year K. 1999. Ah. Ah.
The land was purchased by late grandfather of Krishna. They are not considered that much. They are taking us the land was vested with government, but there is no
Vested with government because there is arrears of payment of land revenue. ಪಡ ಆಗಿದೆ. ಕ್ಯಾನ್ಸಲೇಷನ್ ಅಂದ್ರೆ ಏನು?
ಸರ್ಕಾರಿ ಪಡ ಅಲ್ಲ, ಬಿಲಾಂಗ್ಸ್ ಟು ಗವರ್ನಮೆಂಟ್ ಅಂತ ಗ್ರಾಮವು ಈ ಹಿಂದೆ ಜೋಡಿ ಇನಾಮ್ ಗ್ರಾಮವಾಗಿತ್ತು. ಫಾರ್ಮ್ ನಂಬರ್ 8 4 ಟ್ರೈಪ್ ಮಾಡಬೇಕು ಎಂದು ಆದೇಶಿಸಿ ಸರ್ಕಾರಕ್ಕೆ ನಿಷ್ಠಗೊಂಡಿರುವುದರಿಂದ ಪಹಣಿ ಕಲಂ ನಂಬರ್ 9ರಲ್ಲಿ ಸರ್ಕಾರಿ ಎಂದು ಬರೆಯುವುದರ ಬದಲಿಗೆ ಪಡ ಎಂದು ತಪ್ಪಾಗಿ ಬರೆದೆಂದು ಕಂಡುಕೊಂಡಿದೆ. ಸರಿಪಡಿಸಿಕೊಳ್ಳಲು ಸೂಕ್ತ ಆದೇಶ ನೀಡಿ ಸೂಚಿಸಲಾಗಿದೆ. ಹಾಗೂ ಇದು ಪಡ ಜಮೀನಾಗಿಲ್ಲದಿರುವುದರಿಂದ ಪಡ ರೆಸ್ಟೋರ್ ಮಾಡುವ ಪ್ರಶ್ನೆ ಉದ್ಭವಿಸುತ್ತಿಲ್ಲ. ಇದನ್ನು ಸರ್ಕಾರಿ ಜಮೀನು ಪರಿಗಣಿಸಲು ಸೂಚಿಸಲಾಗಿದೆ. This is the contention. My contention is my great grandfather purchased the said land from the earlier owners. Again, ಈ proceedings ನಲ್ಲಿ ನಂದು ಆರ್ಟಿಸನಲ್ ಕೈ ಬಿಟ್ಟಿದೆ. ಅದನ್ನ ಪಡ ಅಂತ ಕನ್ಸಿಡರ್
ಯಾವಾಗ?
1960 ನಲ್ಲಿ ಪರ್ಚೇಸ್ ಮಾಡಿದ್ರು. grandfather purchased the land
Ah.
in the year 1960.
Ah.
Here also the lots, my father and brothers are.
His name was entered. His name was entered in the land records. Huh?
Lachaya with Chikka Hanmaya. He is the brother of my great grandfather. Now, my great grandfather purchased the land through Lachaya. This was said property in the name of my great grandfather. Yeah, from Miller's the name of the my great grandfather was not protected. Not to say
When did he purchase? ಅವಾಗಿಂದನೂ ಎಂಟರ್ ಆಗಿಲ್ಲ ಅಂತಂದ್ರೆ ವಾಟ್ ಇಸ್ ದ ಮೀನಿಂಗ್? ಅವಾಗಿಂದನೂ ಎಂಟರ್ ಆಗಿಲ್ಲ ಅಂದ್ರೆ ಅರ್ಥ ಏನ್ರಿ?
Now purchased two items, 272 per 1 and 272 per 3. Only 272 per 1 have sold in favor of some other person. Or equal Kata Pata. What items I have purchased?
There are subsequent sale deeds also.
I said, but this
Huh?
272 per 1 property. And sale money in there.
Lachaya executed sale deed in favor of his brother Rangappa, 1972. Rangappa and his brothers entered into partition, 1981. But ಯಾವ್ದು mutation entries ಇಲ್ವಾ? ಮತ್ತೆ what were you doing then? ಅಲ್ರಿ ಹೆಸರನ್ನ ಎಂಟ್ರಿ ಮಾಡಿದ್ರೆ ನಿಮ್ ಪಾಡ್ ನೀವು ಸೇಲ್ ಮಾಡ್ಕೊಂಡು ಹೋದ್ರೆ ವಾಟ್ ಯು ಮೀನ್ ರೆವೆನ್ಯೂ? ಯುವರ್ ಫಾಲ್ಟ್ ಇಟ್ ಈಸ್.
In year 1968 itself, they are mentioned as Sarkari Pada.
Learned AGA takes notice for all the respondents. Learned counsel for petitioner is directed to serve a copy of the petition along with annexures from the learned AGA. Full stop. The respondents are directed to file statement of objection within a period of 3 weeks from this time. Yes. Huh? Two thousand ten. ಅದಕ್ಕೆ ನಮ್ಮ ಮುಂಚೆ ಯಾರ ಹೆಸರು ಇತ್ತು ಖಾತೆ? ಯಾರು? ಏನು ಫಾದರ್ ಹೆಸರು? ರಂಗಸಾಮಯ್ಯ, ವೆಂಕಟಸಾಮಯ್ಯ. You have produced the RTCs? So that also was entered. The partition deed, in terms of the partition deed, the names of the was entered. ಯಾರ್ದು ಬಿಲ್? ಯಾರ್ದು ಬಿಲ್? Second respondent is your brother. Annexure? Page number? ಹಾ ಹ್ಮ್ ಹಾ ಹಾ ಹ್ಮ್ ಇಟ್ಸ್ ಅನ್ ಓರಲ್ ಪಾರ್ಟಿಷನ್ ಹಾ unregistered partnership partition deed ಹಾ 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 in terms of that unregistered partition deed huh? no share was given to him ಎಷ್ಟು ಆಯ್ತು ಅಸಿಸ್ಟೆಂಟ್ ಕಮಿಷನರ್ ಅಲೌಡ್ ದಿ ಅಪೀಲ್ ಹಾ that submission you should make before the assistant commissioner ಬರೋದಿಲ್ಲ matter is pending before the assistant commissioner go participate in the proceedings you make this submission let us see how we will consider you cannot foreclose the rights of the other party irbodu sir these are all matters to be considered by the assistant commissioner you can't foreclose the rights of the party who has a statutory appeal he is aggrieved by that he is filed an appeal in terms of section 136(2) which is permissible in law ನೀವ್ ಹೇಳಿ ನೀವ್ ಏನ್ ಬೇಕೋ ಹೇಳಿ ಬರ್ಕೊಳ್ಳಿ sir you bring it to the notice of the assistant commissioner who is stopping you from bringing it to the assistant commissioner learned AGA takes notice for respond number 1 notice to respond number 2 is not necessary for the following reasons next para the petitioner is seeking to raise a challenge to the proceedings initiated by the second respondent before the first respondent assistant commissioner, Doddaballapura subdivision in RA bracket T close 525/2023. Stop. The second respondent has invoked section 136 bracket 2 of the Karnataka Land Revenue Act of 1964, challenging an endorsement issued by the Tahsildar and the mutation entry made earlier in MRT 32/2022-23. So, next para. Learned counsel for the petitioner seeks to contend that the appeal could not have been filed before the assistant commission. Also, it is contended that the opinion of the Tahsildar is in accordance with law, and if at all the second respondent is aggrieved, he should approach the civil court. Stop. Next para. Contention of the petitioner cannot be accepted. Stop. There is a statutory appeal provided in section 136 bracket 2 of the Act for any person aggrieved of any orders passed by the Tahsildar in respect of the revenue entries made in the record of rights. So, all contentions which the petitioner is seeking to put forth, including the contention that the matter should be decided by a competent civil court, and not the assistant commissioner can be put forth before the assistant commissioner. Full stop. If such contentions are put forth by the petitioner, the assistant commissioner is bound to consider such contentions and pass necessary orders in accordance with law. Full stop. Next para. In that way of the matter, since there is no merit in the writ petition, the writ petition stands dismissed. Huh? Ex-serviceman.
ಈ ಚಟ್ಟಂಬಂದಿ ಒಳಪಟ್ಟ ರಾಷ್ಟ್ರಕ್ಕೆ ಸೈನಿಕ ಕೋಟದಲ್ಲಿ ಅರ್ಜಿದಾರರಿಗೆ ಮಂಜೂರು ಮಾಡಲು ಯಾವುದೇ ಸಂಖ್ಯೆ ಕಟ್ಟಿರುವುದಿಲ್ಲ. ಮಾಜಿ ಸೈನಿಕರಿಗೆ ಸಾರ್ವಜನಿಕ ಸರ್ಕಾರ ಗೋಮಾನ ಮೂರು ಕಾಯ್ದೆ ಸೆಕ್ಷನ್ 416 ಸೈನಿಕ ಕೋಟದಲ್ಲಿ ಮಂಜೂರು ಮಾಡುವ ಬಗ್ಗೆ ಗ್ರಾಮಸ್ಥರು ಮೋದಿನವರೊಂದಿಗೆ ವರದಿಯನ್ನು.
When did you file the application? In the year 2021. 22 to 2021. Huh? Where are you asking for? Yes. Huh? Learned HCDP takes notice for all the respondents. Learned counsel for petitioner is directed to serve a copy of the petition along with annexures from the learned HCDP. Next para. Learned HCDP is directed to secure instruction on the respondent authorities as to why no orders are passed on the application filed by the petitioner in spite of the recommendation of the revenue inspector. So, release this matter on 7th of February.
Petitioners requested to act upon the order and return the revenue. That cannot be. It's a pattern of comparing order. The partition deed was on 1959. Entered between the petitioner's father and the private correspondence. Application when the revenue is responsible. Directly to the revenue. This one is against the petitioner responding because the innocuous order. So based on this partition, we after this one, because in my name, that was challenging ultimately directed. Like that limitation in the partition. Requested representation and annexure B and C to comply the order of dishonorable because there is no time limit of the mention envelope, so I cannot move the content. Please get secretary. D and E envelope the state commissioner and deputy commissioner will forward it to the facility to act upon the representation of the
You are not a party to that proceeding. Respond number 6. Ah. 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 You were opposing. Ah. Your father?
Private response.
Hmm.
After my father challenge before the AC. So
Your name is already entered. Ah. Ah. Sorry, ಆಯ್ತು. Yes.
Challenging the restriction by the private person. Ultimately, this all goes to the registered partition. For the registered partition. After the regulated partition, I have argued, then I have to work out my remedy this week. That is the process.
Then
Completely accepted the
at present, whose name is there?
I think that the petitioner's name is there.
Huh?
Petitioner who are in the next area, petitioner.
How?
What has happened, challenge before the 136 3 months. The appeal which was allowed by in favor of the petitioner there, that was already active. Could have provisional principle only and order compliance with the order.
ಅಲ್ರಿ ಇವಾಗ ಯಾರ ಹೆಸರು ಇದರಿ? So therefore, even in terms of paragraph number 8, you have that liberty.
If I'm upgrade against that entries, I have to work out the remedy this will. Complaints of dishonorable court order. Partition deeds was that.
We can't understand what is your problem. You want, see, ultimately you have to approach the civil court. What are you trying to do now? So therefore, are you aggrieved of the entry made in the RTC? Sir, you are saying the revenue entries are now standing in the name of Sidraju and others. Are you not aggrieved? ಅದು ಬಿಡ್ರಿ ಆಯ್ತು. Ultimately, you have to go to the civil court. What are you waiting for?
Ultimately, both accept the partition deed and the registered partition. Also accepted partition deeds for current RBA. Even for the petitioners, they also not challenging. I also accepted.
And you have not made them parties also here. No. ಹಂಗಾಗೋದಿಲ್ಲ. You make them parties, let them come. We will see. Learned counsel for the petitioner seeks leave of this court to arraign The petitioners in WP number 9458 of 2022 as party respondents to these proceedings. Full stop. Leave is granted. Full stop. Learned counsel shall carry out the amendment in the cost rate. Forthwith. Release this matter on 7th of February.
Now we are. As the father of the petition died not leaving behind the bill. But that was objected by the fifth respondent. And the Tahsildar
Who is the fifth respondent?
he disputed what was the entry and the matter was referred to Tahsildar. Tahsildar was asked an order section D on 2021 section D1. Removing the objections and directed to continue the entries because not the name of the dead person cannot be continued. Therefore, also the directed to continue the name of the petitioner as a successor. But then he filed an appeal before the Supreme Commissioner.
2013.
How? 2013. But he filed an appeal before the Supreme Commissioner. Why the Supreme Commission not allowed the appeal and certified the petition and directed the.
This entire procedure is incorrect. Once objection is raised, they cannot decide. They have to direct you to go to the civil court. Your name could not have been entered.
Here, it's one verse issue.
That is the decision of this court in terms of the rules. If an objection is raised, the name of the person cannot be entered. Let it be. So what?
The suit is already filed.
Who has filed the suit?
But the brothers of the petitioner have filed to have only the plain answer.
Now you are agreed of which order?
I am agreed by the order that should be conformed with the deputy connection A. Connection B at page number 18. Should be 26 page number 20.
No, we'll straight away come to the order of the deputy commissioner.
Yes. But he gave a finding as it is
The said will appears to be unregistered will. A xerox copy of this.
Property, when once connected to family, will become joint family property. No individual can claim ownership on the entire property granted by the license.
Anyway, he could not have gone into all those aspects.
That is why the day must come in the way of my claim was in this.
E observations, civil court will not take into consideration. No.
Now they have taken second. This has said that it is any. This is the higher claiming authority in the district. Whatever the contention by the claim.
ಏನು revenue authority ಅಂದ್ರೆ? Revenue authority, that's all. Their findings in respect of the ಹೌದು. No. ನೀವು not even that. It has no persuasive value. Only the presumption. Ashte. Presumption of an entry in the record of rights. Ashte. Anyway, that entry was made in your favor on the basis of a will. That is disputed now. Now the civil court will decide.
If the entry is continued as per the mutation, so nothing. Ultimately, the mutation entry will not decide the title. Will not hold that I am title holder. Ultimately, the person who is liable to pay the tax finally inverts the mutation entry difference. Therefore, the entry is continued till disposal of the
No.
Because I have one hurdle. I have paid a loan. I have been in cultivation of the land. I have mortgaged the property and evade the loan. Because once the land is got removed from my name, the bank will proceed against me to recover the entire loan.
No. Why? If you are continuing to pay the EMIs, where is the question of all this? Nothing will happen. Parkale. Learned AGA. HCP takes notice for response number 1 to 4. Notice to respond number 5 is not necessary for the following reasons. Next para. The petitioner is aggrieved of the orders passed by the Assistant Commissioner as well as the Deputy Commissioner, who have passed orders in terms of section 136 bracket 2 and 3 respectively. Stop. Next para. It is the contention of the petitioner that in terms of the unregistered bill left behind, unregistered bill dated 4/8/1982, left behind by the petitioner and fifth respondent's father, Sri Tyampanna T. Shetty, ಒಂದೇ property na? All the properties are in dispute. Huh?
Yes, all property included in the suit connection is the paint.
Our property no ನಿಮ್ಮ ಹೆಸರಲ್ಲೇ ಮಾಡ್ಬಿಟ್ರಾ?
Oh, our property.
Nothing for him.
There 1 to 10 lots are family properties. Item number 11 to 15 lots standing in my name.
Huh?
Item number 11 to 15 standing in my name. Pursuant to the will. That is only in this.
ಅದು ಯಾಕೆ ಅಂತ?
But it is based on will plots. They are all the brothers are not cultivated plots. They are all settled in
all right.
other states.
All right. ಏನು ಹೇಳಿದ್ರು?
Attention of the petitioner that in terms of the unregistered bill dated 4/8/1982 left behind by petitioner and the respondent number 5 father Sri Tyampanna T. Shetty.
The record of rights were mutated in the name of the petitioner in respect of the lands in question. So, however, the Assistant Commissioner, in an appeal referred by the fifth respondent, brother of the petitioner, Annexure C1. Huh? Allowed the appeal and directed and set aside the mutation orders passed by the Tahsildar, which was in favor of the petitioner. So, the revisional authority, Deputy Commissioner, dismissed the revision petition filed by the petitioner. So, during the course of these proceedings, it is brought to the notice of this court that respondent number 5 has filed and other brothers have filed a suit in OS number 488 on the file of Bantwal, seeking partition and separate possession, including of the suit scheduled properties, including the lands in question. Stop. Next para. The opinion of the Deputy Commissioner is that all the legal heirs of late Sri Tyampanna Shetty have right over the lands in question as per the Hindu law and custom. And therefore, the revenue entries could not have been mutated only in favor of the petitioner. Stop. When this court expressed its opinion that the law is well settled in this regard, that disputed questions of title cannot be decided by revenue authorities, and it is a competent civil court alone which can decide the disputed questions of title, learned counsel expressed his apprehension that the findings of the deputy commissioner in the impugned order at Annexure A may prejudice the case of the petitioner before the civil court. Full stop. Next para. Any findings given by the revenue authorities in such proceedings under Section 136 of the Karnataka Land Revenue Act will not have any bearing in the civil cases, in the matters to be considered by the civil court. Stop. In that view of the matter, this writ petition stands disposed of, while making it clear that the civil court, which is seized of the suit in OS number so and so, shall not be prejudiced by the findings of the deputy commissioner in the impugned order. Full stop. The civil court shall consider the matter on merits and pass a judgment in accordance with law, ordered accordingly. Service matter. ಯಾರು ಕ್ಲಾಸಿಫೈ ಮಾಡಿದ್ದು? ನೀವು ಮಾಡಿರೋದು. It was you were required to classify. No. You have to do it. You have to do it. Why did you leave it blank? The matter is of service roster. Full stop. Office is directed to reclassify the matter as service arrest and place before the bench having roster. Date now kodak baradilla. You know, 2019, your state is still coming up for preliminary hearing. Notice has not been issued. Yaru? Huh? No, sir. Notice order agilva innu. What are you challenging? 2015. Land revenue matter ಅಥವಾ land reforms? Land reforms, Learned AGA takes notice for response number 1 to 3. Issue notice to respond number 4. Learned counsel for petitioner is directed to serve a copy of the petition along with annexures on the learned AGA. ಏನ್ರಿ ಅಡ್ರೆಸ್ಗಳು ಈ ತರ ಬರೀತಿರಲ್ಲ, ಸರ್ವ್ ಆಗುತ್ತಾ ಇವು? ಹಾ
ಅಜಿತ್
revision petition, the 136(3). Who approached the assistant commissioner? Where is the order of the assistant commissioner? 38.
There was a entry in the revenue department that was set aside by the state commissioner, page number 42 minus. Take entry MRH1. That was set aside, and I was going to in my favor.
You challenge the mutation entry in MR number H 2012-13. Yes.
That was made on the basis of annexure G, my lords.
Registered sale deed executed by the original owner Kenchamma in favor of the appellant was on 11/5/2009 in respect of 1 acre 4 guntas, and the said another registered sale deed had to have been executed by the second respondent as GPA holder of Kenchamma in favor of the third respondent was on 19/5/2012 in respect of the same property.
That was fabricated and concocted. It's the ancestral property. Annexure G, my lords. Can we produce page number 4, my lords?
So your name was entered in terms of registered sale deed dated 2009.
Annexure G, my lords. That existing order does not exist in the office of the assistant. The order was fabricated and that was mutated in the fashion of office. That annexure G, my lords. Page number 4, my
So
lords.
your name was not entered.
First, I did not enter. Then I that this exit, this fake and this assistant commission order not existing. It's still one order, my lord. Page 54 and G, my lord. And the endorsement given by the assistant commissioner that this order does not exist at all.
Huh?
The order fake entry made by the respondent number 3 does not exist in the office of the assistant commissioner, my lord. They fabricated on paper like that and got invitation that in the national office. That the endorsement they issued, my lord. Annexure G, my lord. 54 page number. Can you produce 54 page number?
But that is not the finding of the assistant commissioner.
At that time, we did not knew that the fake order was not at that time. Now, after inquiring into the assistant commissioner office, we came to know that it was just a fabricated.
Whatever it is.
Yes, my lord.
But the assistant commissioner proceeded to set aside
Set aside the order.
the mutation entry.
And in my favor,
Aggrieved, that person approached the assistant deputy commissioner. What is the finding of the deputy commissioner now?
Commissioner upheld the fake order.
On what ground? On what ground?
Order.
That it's a disputed question of law.
My lord.
You will have to go approach the civil court.
Can you produce the page number?
Now, please tell us, sir, is it permissible for the assistant commissioner to say, no, that registered sale deed of the year 2009 is the correct one. She could not have executed another sale deed. How can he say all that?
My lord, my opinion is the order upheld by the deputy commissioner, that is 815, my lord. Order upheld by the deputy commissioner, order number 815/2012 is not, it's a still one order, it is not at all there, the office of the assistant commissioner, which he has not properly examined, and without examining, he has upheld that order, and which order I have got 871.
Sir, at any rate, you approach the assistant commissioner because there was an entry in the land records in the name of the other person. Isn't otherwise, you wouldn't have approached the assistant commissioner at all.
And that, my
Now you can't contend now, there was no such mutation audit. No, anyway, we'll only issue notice, that's all, nothing can be done.
Agreement of the
2000?
And that was registered in the year 2012. In between that, there was one more page registered page was executed in the favor of the contesting respondent in 2009.
Correct.
So the RTC was to be made in the favor of respondent number 3 in 2009 in the correct mutation.
Correct.
It is not in respect of petition because petitioner registered page was of 2012.
Correct. So that is what I'm saying.
So,
Allala, whatever documents you bring, the revenue authorities cannot go into it. You have to go to the civil court.
This order, in effect, where can it go?
You are only wasting your time. All right. All right. Learned AGA takes notice for response number 4 to 6. Issue notice to response number 1 to 3. Learned counsel for the petitioner is directed to serve a copy of the writ petition along with annexures in the learned AGA. Yes.
Number 11, Raghu Prasad BS.
Wakalat filed by V. Chandrasekhar. Neo. In respect of respond number 12. An objection. Aito. Service of notice on 9 and 11. Anyone appearing for 9 and 11? 11. You are already on record? You are already on record for any other respondent? Yaru? What is your name? Who is the learned advocate who wants to file the wakalat? Yaru wakalat hakbekagirodu? Your seniors. Who is your senior? Nishant SK. He is already on record for respond number 10. 11.2. ಕೊಡ್ರಿ ಅದನ್ನು 10604 ಕೊಡಿ. ಇದ್ಯಾವ್ದು ಇದು ಅದು 10568 ಅದು ಕೊಡಿ. $10604 ಅಲ್ಲಿ ರೆಸ್ಪಾಂಡ್ ನಂಬರ್ 10 DH ರಾಮಾಂಜಿನಪ್ಪ ಕರೆಕ್ಟಾ? DH ರಾಮಾಂಜಿನಪ್ಪ. ಅದ್ರಲ್ಲೂ ಅಷ್ಟೇ. You already entered appearance for DH ರಾಮಾಂಜಿನಪ್ಪ. Now you undertake to file wakalat for Patalappa. Respond number 11, na? Already, you are already on record for respond number 10. You are undertaking to file wakalat for respond number 11. Yaru Patalappa na? Ramanjanappa is 10. Respond number 10. You want to file wakalat for Patalappa. Now, according to you, you are already on record for Patalappa, is it? You are already on record. You want to undertake to file or wakalat for another respondent? Yarge? You want to take? Then a counsel say? Huh? K. Shivshankar. ನಿಮ್ಮ ಹೆಸರು ತೋರಿಸಿಲ್ಲ ಇಲ್ಲಿ.
Other two cases, 644.
Yes. Learned counsel K. Shivshankar undertakes to file wakalat for Sri Patalappa, who is respondent number 11 in WP number 10568 of 2022 and 10604 of 2022. A week's time is granted. A week's time is granted to do the needful. ಅಲ್ಲಿ ಬಂದಿದೆಯಲ್ಲ ನಿಮ್ಮ ಹೆಸರು. ಒಂದ್ ನಿಮಿಷ. So notice to respond number 12 K.C. Shivashankarappa. Eleven 11.1 and 11.2. 10 to 18. 10604. 10 to 18. Why are you seeking dispensation?
There were 4 revision petitions. Few of the petitioners, since the common office raised an objection that all to be made parts.
ಹೌದು.
So those parties who are not in the revision petition, they are not participating. Those are also not made parties to the those parties are speaking.
But the learned counsel is saying he'll undertake to file wakalat.
Let's fight the revision petition for 13/2019. Only actually 4 petitions are identified. The others are not.
Four respondents.
Not an annexure page. Yes, that's not even they have paid not said to distance the respondents. By filing revision petition, they had made some of them with responding also. So I had to make it part.
There are 4 revision petitions.
Those petitions are respondent contesting respondent. Therefore, others are adjudication of.
No, but what is the issue? All the other respondents are related. They are related. They are related. Why did you make the other persons party to the revision petition?
They are state committee. That's their contention. But some properties they have purchased. The petitioner. Apart from their contention, they are in possession of some expense of. Assistant commissioner has said that on the basis of position, revenue entities have to be rectified. That is the finding of this. But we have challenged it before the deputy commissioner. Our contention, whatever we have purchased to a registered service, according to mutations of the that is the finding of the deputy. Now the assistant commissioner order has to go balance. On the basis of position, revenue entities cannot be affected.
Who are the other respondents?
Other respondents, they have made
who are they?
They are
Of?
family property. That's no.
Order of the deputy commissioner. Yes. Yes.
They have purchased the land in survey number. This is their contention. Who are the petitioners here? Survey number 243, measuring 5 meters. Survey number 178, measuring 0.98 meters. Survey number 24, measuring 2.8 meters.
ಆಯ್ತು ಅಲ್ಲ ಟೋಟಲಿ ಮೆಜರಿಂಗ್ 31.08 ಗುಂಟಾಸ್. ಹಾ. From its previous owners, namely Siddappa.
Have not acquired any portion of land in survey number 180 of Kalkere village, but they are contended that they are in position of land in 26 meters of land in survey number 180 Kalkere village. So called position is without valid title. Then there are contrary to the of the order dated 8/7/1964. In case number so and so, passed away the additional special deputy commissioner for enhanced abolition. It clearly shows that land measuring 8.8 meters in survey number 180 Kalkere and been granted in favor of the Anjappa son of Punyamaya. The father of the petitioner hearing, or his name had not, has also been dictated in RPC. Subsequently, after the death of the Kata of the Senate has been transferred in the name of Anjappa and so on. So, as per INC 6 of 1988, later MR 18/99, and said the 18.8 meters has been divided between the petitioner, allotting to 0.04 meters. Thus, it is very clear that respondent court will have 4 and 5 have not acquired any title interest any over portion of 180 of Kalkere village. On the contrary, all of the petitioners have acquired the said so and so meters under the due process of law, and later the same succeeded.
So your claim is only in respect of 8.08 guntars. ಅಷ್ಟೇ. But he is claiming to be in possession of 26 guntars. Anyway, you are only concerned with 8.08 guntars. Yes.
What has happened is, they claim that they have purchased this land and some claim by virtue of the gift deed of the year 1974, but those lands are not in existence at all. Now that is the finding which the Tahsildar has recorded to say that these persons' lands are not available, and they have not claimed any mutation entries until I got the mutation. And then
How did you get the mutation in?
I purchased land in 87.
Was survey number 180?
All these lands are abutting.
Sir, survey number 180, does it find a reference in your sale deeds?
Not in my sale.
Then?
Yes. That is the reason I said you have annexure B.
So it is clear that you are seeking to claim that you are in possession of this land,
Yes.
and therefore your name should be entered.
Yes.
The deputy commissioner has held no, that is not the law.
Carried out. Specifically ordered.
All that will become disputed question, which will be decided by the civil court. We are only concerned with the revenue entries. We are not saying who is in possession, who is not in possession. Adu barade illa idralli.
I understand.
So therefore, what is wrong in the order of the deputy commissioner? Please point out.
But as I said, Lord, actually, DC has not been to the.
You go to the civil court.
Yes, Lord. I have filed an injunction to protecting my person.
Yes,
But
please do it.
they have.
We are only concerned with the revenue entry.
But if this honorable court were to say that mutation entries in absence of a title to me, but mutation entries give rise to the presumption that a party is in possession.
Huh?
Mutation entry.
Huh?
Yes, we give rise to a factual presumption that they are in possession.
No. Mutation entry is a presumption
Yes.
that there is an entry in the revenue record. Ashte. Adbit enu illa. It doesn't say anything about possession. Ashte.
My submission is that if they were to say mutation.
Anyway, you have already filed a suit.
I filed a suit for injunction. They have not filed anything for declaration in day.
Why should they?
They are not in possession. But they.
If you want to protect your possession, and if you say that is enough for me, do so.
That is the reason I said.
You cannot maintain your name in the land records without there being any registered document in your favor.
Now these mutations are carried out based on the survey carried out as per possession.
ಅದನ್ನೇ ಸರ್ ಹೇಳ್ತಾರದು. ನೀವ್ ಎಷ್ಟು ಹೇಳಿದ್ರು ಅಷ್ಟೇ ಬರೋದು.
My learned friend said they are in possession. They are not in possession.
ಅವ್ರು ಏನ್ ಬೇಕಾದ್ರೂ ಹೇಳ್ಬೋದು. We are not concerned about possession. We are only concerned with the revenue entries in terms of section 128 of the Land Revenue Act.
Their land is not available because of the reason not.
Maybe.
It
So
is
what?
not available now.
We are not saying anything about that. We are only concerned with the revenue entry. There is nothing wrong in the order of the deputy commissioner.
With regard to state, with regard that based on my saying that the state survey number is not available.
Ashte,
That is the reason.
ashte. That is the reasoning.
My submission is not because of the long possession. Not.
ಬರೋದಿಲ್ಲ.
because state is-
ಯಾವ ಕಾನೂನು ಕೆಳಗಡೆ ಬರುತ್ತೆ? If you are in long possession, your name can be entered ಅಂತ.
It is not going to have it on Monday.
There cannot be any law contrary to the statutory law. There cannot be any other law.
Limitation Act gives me a reason to say that duration, long duration, but I become adverse by way of.
ಅಲ್ಲಿ ಏನ್ ಬೇಕಾದ್ರೂ ಹೇಳ್ಕೊಳ್ಳಿ ನೀವು. ವಾಟ್ ಎವರ್ ರಿಲೀಫ್ ಯು ವಾಂಟ್ ಟು ಟೇಕ್, ಯು ಪ್ಲೀಸ್ ಟೇಕ್. Please tell us what is wrong in the impugned order.
DC goes in so far as only my saying that the sex survey number is not there.
That is how, that is the position of law. In terms of section 128, any person who acquires title in a manner known to law, as it is stated there, is entitled to have his name entered in the land record. That is all.
This court tried to hold that the question of possession,
Here,
long duration,
definitely no.
that it will not give a presumption that they are in possession. In the
No, definitely no.
I can protect my possession.
No such presumption. Presumption is only that the entry is made in terms of a registered document as provided in section 128. Ashte presumption. Perfect.
Attention that I am in possession is recorded.
Yes, yes. ಅದೇ ಅವ್ರ ಕಂಟೆನ್ಷನ್ ಹೇಳಿ ಅಂತಾರೆ, ಆಯ್ತು ಹೇಳೋಣ ಬಿಡ್ರಿ.
That is
We
the,
will record your contention also.
but there is a actual finding given by both AC as well as Arthur, that that's what, that they are not in possession. That is not.
They cannot do that.
But that is the reason I have been stressing on the point that they will, on the basis of any increase now, which was not available for more than 5 decades. But 1% clear 1974 50. There is no entry indication from 1974 up to 2022. There is no entry.
These 4 writ petitions arise out of a common order passed by the deputy commissioner from Bangalore Urban District in revision petitions number 595 of 2017, 616 of 2017, 692 of 2017, and 13 of 2019, dated 31st of March 2022. So, although some of the respondents in repetition number 10568 of 2022 and 10604 of 2022 have not been served, the learned counsels for the respondents, private respondents, have jointly submitted that those persons were not necessary even before the revenue authority. So, they have not contested the matter. So, it is only respondents number ನೀವು 4 ಜನ ಯಾರು? It is only the revision petitioners before the deputy commissioner who are the necessary parties to these proceedings, and all of them have been represented in these matters. Full stop. Therefore, without waiting for the service of notice on such other respondents, with the consent of the learned counsel for the petitioners as well as the contesting respondents, comma, the matter is taken up for final disposal. Full stop. Next para. Annexure B is the order of the Tahsildar. Allah, Tahsildar order, Annexure B, dated 30/5/2014. That was what was questioned before the Assistant Commissioner, is it?
Challenge before the Tahsildar what? Then he is able to stay.
Ah,
That was what he and
I, but
challenge C. Section C may be that challenge the revenue increase and MR.
Akkappa and Munianjanamma. Respondents, huh? Respondents.
Section C may be section C may be that number. If I cut from the right and do the effect seeking direction to customer's point traffic effect in case in the name of them.
There was only one appeal before the Assistant Commissioner.
Yes.
Only one.
Survey numbers will not, they are claiming 26 acres. We are all claiming portion of land 180. 8 acres, 9 acres, 10.
Right, with respect of survey number 240.
Claiming 1887 said it blood. That said it does not disclose the survey number 180 and other. Therefore, the court division and the least and said that without identity, they are not challenge the revenue because they said it there is no survey number.
ಎಲ್ಲ ಬೇರೆ ಬೇರೆ ಸರ್ವೆ ನಂಬರ್ಗಳೆಲ್ಲ ಇದೆಯಲ್ರಿ ಇದ್ರಿ?
But only
I have been not against the I but my challenge before the assistant commissioner itself was is not survey that was carried out as per suggestion. That is mentioned at Karnataka. So
ಪ್ಯಾರಾಗ್ರಾಫ್ ಮುಗೀತು ಅಷ್ಟೇ ತಾನೆ? The two petitioners herein, namely Sri Akkappa and Munianjanamma, filed an appeal before the Assistant Commissioner, Bangalore North Subdivision in RA bracket BE close 331 of 2015-16. Invoking section 136 bracket 2 of the Karnataka Land Revenue Act of 1964, seeking directions to the Tahsildar to effect the mutation entries in the name of the appellants therein in respect of 26 guntas of land in survey number 180 of Kalkare village, Kiarpura Hobli, Bangalore East Taluk, amongst along with a few other survey numbers. Stop. But in this writ petition, we are only concerned with survey number 180. Adu idya? Huh?
Not read back portion. The same paragraph. Survey number 180 measuring 26 gunta. Survey number 241 measuring 0.08. Survey number 243 measuring 0.13. So 4 survey numbers. Those 4 survey numbers I am claimed, but I am in possession. I do not have that.
All false survey.
So that
So,
survey numbers.
all right. All right. ಇಲ್ಲ ಅದು ತೆಗೆದು ಆ ಸೆಂಟೆನ್ಸ್ ತೆಗೆದಾಕ್ಬಿಡಿ, ಪ್ರೀವಿಯಸ್ ಸೆಂಟೆನ್ಸ್ ಓದಿ.
Direction to the Tahsildar to effect the mutation entry in the name of the appellants therein in respect of 26 guntas of land in survey number
180, 8 guntas in survey number 241, 8 guntas in survey number 242 and 13 guntas. 8 guntas ಇರ್ತಾನೆ, 8 guntas ಇರ್ತಾನೆ. And 13 guntas in survey number 243 of Kalkere village, Kiarpura Hobli, Bangalore East Taluk. Stop. So who are these contesting respondents? Kantamma, one ನಿಮಿಷ, ಕಾಂತಮ್ಮ, CH ರಾಮಾಂಜನಪ್ಪ, ಪಟಾಲಪ್ಪ, KC ಶಿವಶಂಕರಪ್ಪ, ಇವ್ 4 ಜನನಾ? Who are they? ಅಲ್ರಿ No, they said the other parties are not interested parties. So I'm trying to find out who are those other parties. And Assistant Commissioner order banri. Who are the contesting respondents? Kantamma, Ramanjanappa, Patalappa, Shivshankarappa, ಆಮೇಲೆ ಮುದ್ದಪ್ಪ, ಅಷ್ಟೇನಾ? ಕಾಳಪ್ಪ, ಇವರು ಇದಾರೆ, ರಾಮಚಂದ್ರಪ್ಪನು ಪಿಳ್ಳಾಂಜನಪ್ಪ ಅವ್ರ ಮಗನೇ. ಆ ಅಲ್ರಿ, ಕಾಳಪ್ಪ ಅಂಡ್ ಮುದ್ದಪ್ಪ ಆರ್ ಆಲ್ಸೋ sons of Pillanjanappa, and this Ramchandrappa also is son of Pillanjanappa, and Nagendra also is son of Pillappa. All of them are ಏನಮ್ಮ
8 quintas in survey number 241, 8 quintas in survey number 242, and 13 quintas in survey number 243 of Kalkere.
Right. The contesting respondents herein were notified by the assistant commissioner, and they contested the matter before the assistant commissioner. So the assistant commissioner accepted the contention of the petitioners herein that although by virtue of their registered sale deed dated 8/9/1987, they had purchased properties in survey number 243 measuring 5 quintas, survey number 178 measuring 9.08 quintas, survey number 241 measuring 3.08 quintas, survey number 179 measuring 10 quintas, and survey number 242/3 measuring 3 quintas, totally measuring 31.08 quintas of Kalkere village, nevertheless, as per the Mazar report, they were in possession of the other lands in question, which according to the contesting respondents are their properties. So, nevertheless, the assistant commissioner directed the Tahsildar to effect mutation entries in the name of the petitioners herein, who are the appellants before the assistant commissioner, in respect of the lands in question, although admittedly the petitioners herein had no title to the properties. Full stop. Agreed by the said order, the contesting respondents herein filed 4 revision petitions before the deputy commissioner, and the deputy commissioner accepted the contention of the contesting respondents herein that such a direction given by the assistant commissioner would be contrary to the law as provided in section 128 of the Karnataka Land Revenue Act. So, next para. On hearing the learned counsel for the petitioners, the contesting respondents, and the learned AGA, and on perusing the petition papers, it is clear that the petitioners have admittedly not purchased the lands in question under the registered sale deed dated 8/9/1987. So, the lands purchased under the said sale deed are different and not the lands in question. ನಿಮ್ಗೆ ಹೆಂಗ್ ಬಂತು?
Apparently, the business have paid a part of the regular rate. And it is required people to pay regular rate. Thereafter, they are paid this.
Revision petition, 12 insofar as the
Also purchase their assets for registered documents. Some of them are registered documents, some of them are.
DC under para 12
23, paragraph 23. 12.
Clearly shows that the CH mandal of Bharat is with the land 9 meters when were 180 and from the use of the registered degree. So, you show the CH mandal of our gifted is at less than 9 meters, 7 were 180 and starter. Institutional Karnataka and mutation also affected in the name MR3 by 1986-87. But responded for an inquiry without challenging the said mutation, before appropriate forum, without questioning the said registered party should be registered it as well as appeal, seeking for mutation just on the basis of alleged position. Para 12.
ಅದು 180, survey number 180.
That's our claim, you know. The other point very different position of land.
Page 25.
20?
Page 25.
Correct. 26. ಅದನ್ನು ಸರ್ವೆ ನಂಬರ್ 180 ಇದೆಯಲ್ರಿ.
26
All right. ಏನ್ ಹೇಳ್ದೆ?
On hearing the non-consent of the petitioner, the contesting respondents on the land AGA on perusing the petition papers, it is clear that the petitioners have admittedly not purchased the land in question under registered sale deed dated 8/9/1987. The land purchased in the said sale deed are different and not the land in question.
Land in question. The Deputy Commissioner has also narrated the manner in which the contesting respondents herein have acquired title over the respective lands, which is not necessary to be reproduced herein. Full stop. However, it is broadly accepted by the learned counsel for petitioners that the petitioners have admittedly no title to the property in question, having regard to the schedule mentioned in the sale deed dated 8/9/1987. So, nevertheless, learned counsel for the petitioner once again sought to contend, as was contended before the Assistant Commissioner, that the petitioners are in possession of the lands in question from the year 1987, consequent to the sale deed dated 8/9/1987, and the revenue authorities have recognized the long-standing possession of the petitioners of the lands in question. So, moreover, the petitioners have filed OS number so and so before the City Civil Court at Bengaluru, seeking permanent injunction against the contesting respondents herein, to restrain them from interfering with the peaceful possession of the suit schedule properties, which are none other than the lands in question. Learned counsel would further submit that the City Civil Court has directed the parties to maintain status quo insofar as the possession is concerned. Stop. Next paragraph. Having regard to these undisputed facts, this court is of the considered opinion that no infirmity can be found in the impugned order passed by the Deputy Commissioner. Full stop. The Deputy Commissioner has rightly held that in terms of section 128 of the Act, any person acquiring right, title and interest by way of succession, survivorship, inheritance, partition, purchase, mortgage, gift, lease, or otherwise, any right as holder, occupant, owner, mortgagee, landlord, or tenant of the land is entitled to have his or her name entered in the land records. Full stop. That being the position, the assistant commissioner could not have directed the Tahsildar to enter the names of the petitioners, although it was found that the petitioners had no title to the lands in question. Full stop. The assistant commissioner had clearly directed that the revenue entries shall be mutated having regard to the possession of the lands in question, which is contrary to what is provided in section 128 of the Act. Full stop. Next para. Moreover, the petitioners have approached the civil court, but only seeking a decree of permanent injunction to protect their possession. Full stop. In this writ petition, this court is only concerned about the revenue entries and the orders passed by the assistant commissioner and the deputy commissioner who are the custodians of the revenue records. Stop. The revenue authorities are required to maintain the revenue records in accordance with the provisions contained in the Act. Stop. This court is not concerned with the question of possession that is sought to be put forth by the petitioners, which was also not to have been considered by the assistant commissioner, as was done in the impugned order. So, having regard to all these admitted facts, insofar as the registered documents are concerned, this court is of the considered opinion that the deputy commissioner has rightly arrived at a conclusion that the revenue entries can be maintained only in accordance with the provisions of the law as provided in the Karnataka Land Revenue Act, 1964, and not in terms of the possession. Stop. Next para. Consequently, the writ petitions stand dismissed. Sir, there are already orders passed now earlier. Yes. OT to be paid in respect of petitioner number 1A to 1C. ಅದನ್ನು ಕಟ್ಟಿದ್ದೀರಾ? ಯಾವಾಗ? 13-12. Learned counsel for the petitioners number 1A to 1C submits that additional court fee has been paid on 13-12-2023. Office to verify. ಹೌದು. ಯಾವ್ದು ಐ? Learned counsel would also submit that the learned counsel has made necessary corrections in IA number 1 of 2023, indicating the edition in which the paper publication have to be taken. Release this matter on 7th of February. ಅಲ್ಲ, ಅದು ಇದ್ರದೊಂದು let them verify and say we will pass orders on 7th. 7th. ಏನ? ಹೌದ್ರಿ, ಈಗ್ಲೂ ಇಲ್ವಾ ರೆಕಾರ್ಡ್ಸ್ ಅವ್ರ ಹತ್ರ? ಸರ್, ದಟ್ ಎಂಡೋರ್ಸ್ಮೆಂಟ್ ಯಾವಾಗ ಕೊಟ್ಟಿರೋದು? ಅದು ಎಂಡೋರ್ಸ್ಮೆಂಟ್ 2019. Even if you say some wrong number was given, we are asking what happened to the original records now? Why is he not giving a certificate copy? That is what we are directed. Learned AGA is directed to secure instructions and if possible furnish a certificate copy of the grant certificate. What is this? We know how the public are pleased in the office, but when a problem comes before this court, we are not going to give the same room. If it has to be furnished, it has to be furnished. They can't say we are still searching. Avaga grant register ಇಲ್ಲ ಅಂದ್ಬಿಟ್ಟು ಎಂಡೋರ್ಸ್ಮೆಂಟ್ ಕೊಟ್ಟಿದ್ರು 2019 ಅಲ್ಲಿ. Now what is the problem? Next para. In spite of the specific directions given by this court, certified copy of the grant certificate bearing LND SR 113/6162 in respect of survey number 23 of Tippasandra village, Uttarahallu Hubli, Bangalore South Taluk, is not furnished by the respondent Tahsildar. Stop. Next para. However, at the request of the learned AGA, released this matter on 7th of February 2024. If certified copy is not furnished to the petitioner by the next date of hearing, the concerned Tahsildar shall be kept present before this court. Huh? 24. Jagdish HT. Huh? Huh? ಅವ್ರು ಬರ್ತಾರ ಇಲ್ಲ ಅದೇ on 22/1/2024 the following order was passed. Extract next para. Matter is called out. There is no representation for the petitioner. Office objections have not been complied. So consequently the petition stands dismissed for non-compliance of office objections.
Come on in.
ಬಂದಿದ್ಯಾ? ಅಸಿಸ್ಟೆಂಟ್ ಕಮಿಷನರ್ ಎನ್ಕ್ವೈರಿ ಮಾಡಿದಾರಾ? ಹಾ. ಆಯ್ತು, ಇವಾಗ ಒರಿಜಿನಲ್ ಗ್ರಾಂಟ್ ತಂದಿದ್ದೀರಾ? ಹಾ, ಹ್ಯಾವ್ ಯು ಗಾನ್ ಥ್ರೂ ದಟ್? ಹ್ಮ್. What is your contention? In whose favor it was granted? Petitioner Umesh. ಯಾವಾಗ? 2018. ಹಾ, ಎಂಟ್ರಿ ಇದೆಯೇನ್ರಿ? ಇದೆ. ಹಾ. 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 136 at the instance of the petitioner. Huh? So for cancellation of the grant, for cancellation of the grant under 108K. Already, then how could the Tahsildar make this file? He has filed a stay affidavit saying that the grant itself is concocted. ಇಷ್ಟ ಬಂದಂಗೆ ಮಾಡಕ್ಕಾಗುತ್ತಾ? How could he file this affidavit then? Please see the affidavit filed on 21st of June 2023. Paragraph number 2. Yes. Paragraph number 2. ಏನಂದ್ರೆ ಅವ್ರ ಏನ್ ಇಷ್ಟ ಬಂದಂಗ ಏನ್ ಬೇಕಾದ್ರೂ ಹೇಳ್ಬಿಡ್ಬೋದಾ? He could have said, although it is true that the grant was made, it is found that it was not granted by following the due process of law, and therefore Tahsildar has initiated proceedings before the Assistant Commissioner invoking Rule 108K, seeking cancellation of the grant order. ಇತ್ತಾನೆ ಹೇಳ್ಬೇಕಾಗಿತ್ತು. Sir, that is not the end of it. If they had not followed the procedure, ಅದನ್ನ ನೀವ್ ಹೇಳೋದಲ್ಲ. The Tahsildar is saying, please understand, sir, there is a provision for cancellation of the grant. Therefore, if the Tahsildar has initiated proceedings invoking Rule 108K, notice will be issued to you. You go appear before the Assistant Commissioner. ಯಾವ್ದ್ರಲ್ಲಿ? ಯಾವ ಮ್ಯಾಟರ್ ಅಲ್ಲಿ? ಹಾ, ಏನಾಯ್ತು? And what is your prayer in the writ petition? How? When you say you know the proceedings are initiated under 108K, so therefore, what was your prayer? Earlier, before the institution of the proceedings, you had filed the writ petition. All right. Now there are subsequent developments. We will allow the Assistant Commissioner to proceed to consider the appeal filed by the Tahsildar. ಆಯ್ತು, as of now, this writ petition becomes infectious. Sir, ಹೌದು, subsequently they have initiated proceedings invoking Rule 108K. Let the Assistant Commissioner conclude the proceedings. If he cancels the grant, you will have a cause of action. If he dismisses the appeal, we will direct the Assistant Commissioner that he should also direct to enter your names in the land records. Ashte, perfect. They cannot, sir. How? No, not.
Since they have come, that my name is not included in the RTC invitation.
Sir, it's a wrong statement. In fact, we can take action against the Tahsildar. But it is a fact that proceedings have been initiated saying that the grant made in your favor is not in accordance with law. Then how can they dispose you? If they admit that, ಅದನ್ನ ಹೇಳ್ತಾ ಇರೋದು. ಇವಾಗ if that statement was correct, that there was no such grant made in your favor, what you were brought before this court is a concocted document, then there was something. ಈಗ ಹಂಗಿಲ್ಲ. That is under question before the Assistant Commissioner now. Please go participate in the proceedings. Purple. We'll also have to make an observation against this Tahsildar. It cannot go scot-free like this. Correct, sir. Even if that is so, what is the statement that Tahsildar should have made? Huh? Therefore, we are seeking cancellation of the grant. We have filed an appeal before the Assistant Commissioner invoking rule so and so. That is what he should have stated. How can he state it's a concocted document? It is about the grant order, not about the application filed by the person. How can he say that the order is a concocted order that is furnished by the petitioner? It's a wrong statement. You should be careful. Bakale. Correct. Affidavit is filed by Tahsildar Harohalli. Avaga, that point of time. This writ petition was filed on 25th of October 2021. With a prayer. To issue a writ of mandamus directing the respondents to issue Kata certificate in favor of the petitioner in respect of three acres and 5 guntas of land in survey number 71 of Medamaranahalli, Kanakpura Taluk. We'll stop. It is the contention of the petitioner that the petitioner had sought for regularization of unauthorized occupation of the lands in question, and the committee for regularization of unauthorized occupation passed a resolution allowing the claim of the petitioner. Full stop. Order was passed in LND SR bracket HA close ME close 1/17/18 2017-18 dated 21/3/2018. Confirming the grant in favor of the petitioner. Stop. It is contended that the petitioner was called upon to pay the premium charges, and accordingly the petitioner paid rupees 2,310 on 22/3/2018 from a receipt of which is furnished at Annexure D. Stop. Nevertheless, the name of the petitioner was not entered in the revenue records, and Sagoli chit has not been issued in favor of the petitioner. Huh? ಕೊಟ್ಟಿದಾರಾ? Has not been entered in the land records, and therefore the petitioner gave several representations, including the one on 11/8/2020 and 8/9/2021. To the Tahsildar, Kanakpura Taluk, and the Deputy Commissioner, Ramnagara District, to enter the name of the petitioner in the land records and issue Kata certificate. Stop. Next para. During the course of these proceedings, the concerned Tahsildar was directed to file an affidavit stating as to whether the land which is the subject matter of the writ petition is granted in favor of the petitioner or not. And whether there was any impediment for the Tahsildar to issue Kata in favor of the petitioner. Stop. In terms of the directions issued by this court, the Tahsildar, Arohalli Taluk, Ramnagara District, filed an affidavit on 21/6/2023. This court recorded in its order dated 9/1/2024 that in the affidavit, it is now sought to be contended that the alleged grant made in favor of the petitioner on 21/3/2018 is concocted. Stop. It was also stated in the affidavit that the Assistant Commissioner has initiated proceedings to inquire into the claim made by the petitioner and several other such persons. Stop. This court directed the learned AGA to secure instruction to the Assistant Commissioner as to whether the inquiry has been concluded, and if so, what is the conclusion drawn by the Assistant Commissioner? Stop. Next para. Today, the learned AGA submits that he has secured the original grant register from the office of the Tahsildar, Arohalli. Since the jurisdiction is now vested with the Tahsildar, Arohalli, which was earlier within the jurisdiction of Tahsildar, Kanakpura. On instructions, the learned AGA submits that in the grant register, there is an entry that the land has been granted, land in question has been granted in favor of the petitioner. This would mean that the statement made by the Tahsildar in his affidavit dated 21/6/2023 is contrary to the records. However, learned AGA submits that what the Tahsildar sought to convey was that the form said to have been filed by the petitioner in form number 53. ಏನದು? What? ಅಷ್ಟೇ ತಾನೆ? All right. ಹೇಳ್ದಮ್ಮ?
Kannada AG submits that what they Tahsildar said to convey
Sought to convey was that the procedure contemplated for consideration of the applications for regularization of unauthorized occupation were not followed, and consequently the Tahsildar has approached the Assistant Commissioner seeking cancellation of the grant orders passed by the committee. So, the Assistant Commissioner is now seized of the matter. Stop. Next para. If that is so, it is clear that the statement made by the Tahsildar in the affidavit was without proper verification. Stop. Such statements on oath should be made after verification of the records. Stop. If such conduct of the Tahsildar is repeated, this court will have to take serious action against the said officer. Stop. Next para. Having regard to the subsequent developments, if the Tahsildar has approached the Assistant Commissioner invoking the relevant provisions of law, seeking cancellation of the grant order made by the committee, then the Assistant Commissioner is required to hear the petitioner and pass necessary orders in accordance with law. Stop. Next para. Consequently, the repetition stands disposed of, permitting the Assistant Commissioner to proceed and conclude the proceedings as expeditiously as possible, and at any rate within a period of 3 months from the date of receipt of a copy of this order. So, if the Assistant Commissioner dismisses the appeal filed by the Tahsildar, then the Tahsildar shall proceed to enter the name of the petitioner in the land records. Also, on the contrary, if the appeal filed by the Tahsildar is allowed by the Assistant Commissioner and the grant order is set aside, the petitioner will be at liberty to challenge the same in a manner known to you.
Issue must be.
Huh? ವಕಾಲತ್. ಹಾ. Office objection regarding the wakalat filed on behalf of the petitioner is overruled. Yes. Huh? Keshamurti B. Attagiboda. Stop. Since learned counsel Sri PC Venkatesh is appearing on behalf of the petitioner, the name of learned counsel Sri Keshavamurthy B may be removed from the cause. Punishing process fee. Learned an expert in the connected writ petition. Learned counsel for the petitioner submits that he has paid the process fee. Office to verify and issue notice to respond number 9. Interim orders wherever granted stand extended till the next date of hearing. Seventh time. Learned counsel for the petitioner submits that the typed copy of the manuscripts are ready and the same will be filed in the office during the course of the day. Full stop. Ordered accordingly. For what? Huh? Non-filing of acknowledgement. All right. Before the pass over. Yes, form number 10 also was issued consequent to the directions of the division bench. That is why office objection also was raised in the order of the order sheet that we saw of the assistant commissioner. Office objections were raised. Before the that complete what we
He forwarded it.
Where is the power? No, that is why, see, these kind of acts of the assistant commissioner or the tahsildar cannot be condoned. ಅವ್ರಿಗೆ ಏನ್ ಯಾವಾಗ ಬೇಕಾದ್ರೆ ಇಷ್ಟ ಬಂದು ಏನ್ ಬೇಕಾದ್ರೂ ಮಾಡ್ಬೋದು ಅವರು. So he has not filed any appeal. He has not filed any appeal before the assistant commissioner. And office objections have been noted in the order sheet of the assistant commissioner that there is no appeal memo. No, please put yourself in the shoes of the petitioner. There is no appeal memo, nothing. A notice will be issued. ಏನ್ ಬರ್ಬೇಕು, ಏನ್ ಆನ್ಸರ್ ಮಾಡ್ಬೇಕು, for what? No. If there is no appeal memo, there is no paper to show what is your contention. Now, that is one thing. Is it permissible for the assistant commissioner to invoke 136(2)? One appeal, this here, there is no question of appeal that could be filed because your contention is the allegation in that communication is that the land tribunal could not have passed that order. Aita, illi assistant commissioner under 136(2), what can he do? Even if an appeal is filed by the tahsildar, what can he do? The order of the land tribunal had to be questioned. ಈ ತರ ಒಂದು ಸಮನ್ಸ್ ಇಶ್ಯೂ ಮಾಡ್ತೀರಾ, ಏನ್ ಮಾಡ್ಬೇಕು ಇವರು? That is why I said no appeal memo. They are not aware what they should answer to. Now, what is your prayer in the writ petition? Assistant commissioner. Yes, it's a clear case of abuse of power. Ade, so therefore, under 136, where is the power of the assistant commissioner to consider the orders passed by the land tribunal? Here we are only concerned with the revenue entries.
Confirming the order of the land tribunal, filed by state.
ಅದೇನೋ ಗೊತ್ತಿಲ್ಲ, these revenue authorities think that they are the custodian of all the government lands, which is not so. They are only custodian of the revenue records ಅಷ್ಟೇ. They can't think they are the custodian of all the government lands. That is why I have held in that matter that unless there is an appeal filed by the state through the revenue secretary, no such proceedings can be initiated by the assistant commissioner or the deputy commissioner under 136. I have held so. Adbidi, idalla. This is a totally misplaced proceedings, which they could not have initiated at all. Even in respect of claims where they simply say, no, there was no such grant order made. These are all bogus documents. And How many, any number of such cases are coming up before this court. That is why in those writ petitions earlier I had held, any action should be taken within reasonable time. ಒಂದು ಎರಡನೇದು, unless there is a proceedings sought to be initiated at the behest of the government through the revenue secretary, where will the assistant commissioner or the deputy commissioner get the jurisdiction to issue notice under section 136? Suo moto powers ಏನು ಇಲ್ಲ ಇಲ್ಲಿ. Even for that one, see, it is only question of entry, revenue entries. ಅದೇನು ಮೇಲ್ನೋಟಕ್ಕೇನೆ ಏನಾದ್ರೂ ಒಂದು ದೊಡ್ಡ ತಪ್ಪು ವ್ಯಕ್ತವಾಗಿದ್ರೆ, at least there is some occasion for the deputy commissioner to say, for these reasons I am initiating suo motu powers anta, I am invoking suo motu powers anta. In all these kind of litigations, where is the question of the deputy commissioner invoking the suo motu powers? If the allegation is that there was no grant, their name could not have been entered in the land records, then who has to make the allegation? Who is the owner of the property? State. Unless there is a request from the state, how could the deputy commissioner invoke the suo motu powers? This is what I have written there. Idu bidi, this is totally uncalled for. The petitioners are aggrieved of the initiation of proceedings at the hands of the second respondent, assistant commissioner, Bangalore North Taluk, in proceedings bearing number RA bracket YLK close 576 of 2021, and therefore the petitioners are seeking to quash the entire proceedings initiated by the assistant commissioner. So, the petitioners are also seeking a further direction to the Tahsildar to delete the entries of the entries made in column number 11. Column number 11, regarding an order of stay said to have been passed by the assistant commissioner. Stop. Next para. Learner council. ಇದು ಪೂರ್ತಿ ಪ್ಯಾರಾಗ್ರಾಫ್ ರಿಪೀಟ್ ಮಾಡ್ಬಿಡಿ. ಆಲ್ ಎವ್ರಿಥಿಂಗ್ ಇಸ್ ಕಂಟೈನ್ಡ್ ಹಿಯರ್. 17/1/2022 ಅಲ್ಲಿ ಬಿಗ್ ಪ್ಯಾರಾಗ್ರಾಫ್ ಪೂರ್ತಿ ಎಕ್ಸ್ಟ್ರಾಕ್ಟ್ ಮಾಡ್ಕೊಂಡು. Next para. This court had thereafter noticed in the daily order dated 22/1/2024 that in the order sheet maintained by the Assistant Commissioner, office objections were raised that there was no appeal memo and court fees were not paid. So, the learned AGA was therefore directed to secure instructions from the office of the Assistant Commissioner as to whether a copy of the appeal memo was filed by the special Tahsildar, which forms the basis for the Assistant Commissioner to initiate the proceedings under section 136(2) of the Act. Full stop. However, today, the learned AGA has filed a memo along with copy of a communication dated 6/11/2021 made by the Tahsildar, the then special Tahsildar, Yalanka Taluk, addressed to the Assistant Commissioner. Stop. Learned AGA submits that the special Tahsildar brought to the notice of the Assistant Commissioner a complaint given by one Shri K. Dilip Kumar on 16/3/2021 that the petitioners herein, the petitioner's father had obtained the order at the hands of the land tribunal by concealing relevant information. Stop. Learned AGA submits that on the basis of the said communication, the Assistant Commissioner has initiated the proceedings invoking section 136(2) of the Karnataka Land Revenue Act of 1964. Stop. The learned AGA would further submit that the petitioners have appeared before the Assistant Commissioner and have filed a written statement with all relevant documents. Stop. Next paragraph. Learned counsel for the petitioners would submit that even if it is presumed that the Assistant Commissioner has initiated suo motu proceedings, there is no such provision enabling the Assistant Commissioner to invoke suo motu powers, when such power is not conferred in the statute, in the provision. So, learned counsel submits that subsection 2 of section 136 only provides for an appeal remedy before the assistant commissioner in respect of any order passed by the Tahsildar under section 129 of the Act. Stop. Learned counsel submits that although suo motu powers are vested with the deputy commissioner in terms of subsection 3 of section 136, such powers cannot be usurped by the assistant commissioner who deals with the powers conferred under subsection 2 of section 136. So, even otherwise, it is submitted that when the dispute regarding the orders passed by the land tribunal have attained finality and the revenue authorities have issued form number 10 consequent to the directions issued by the Honorable Division Bench of this court, there was no occasion for the assistant commissioner to once again initiate proceedings under section 136 bracket 2 of the Act on the basis of a complaint said to have been made by a third party. Stop. Even according to the complaint, it is only alleged that the petitioner's father, Sri H. Bailappa, secured orders at the hands of the land tribunal by concealing relevant information. Stop. If that is the case, then the order of the land tribunal is required to be questioned, and such powers are not vested with the assistant commissioner by invoking the provisions contained in section 136 of the Act. Stop. Next para. There is substance in the argument of the learned counsel for petitioner. Stop. The conduct of the second respondent assistant commissioner, Bangalore North Taluk, in initiating proceedings invoking section 136 bracket 2 of the Act on the guise of a complaint received at the hands of one Sri K. Dilip Kumar, would be totally in contravention of the provisions contained in section 136 of the Act. Stop. This court also takes judicial note of the fact that such proceedings are initiated by the assistant commissioner without there being an appeal memo filed by the competent authority or any aggrieved person. Stop. The predicament of such persons who are called upon to answer the assistant commissioner, without there being an appeal memo and any papers put forth to the respondent, comma,
The predicament of such persons who are called upon to answer the assistant commissioner, without there being an appeal memo and any papers put to the respondent.
would be highly precarious. Stop. If such proceedings are permitted to be initiated or continued, comma, it would be nothing but travesty of justice. Stop. Espera. ಎಲ್ಲಿ ಅದು ಇದು RTC that column number 11 entry J9 J9 what are these entries?
Assistant Commissioner actually filed an order in connection with
ಓ ಈ ಪ್ರೊಸೀಡಿಂಗ್ಸ್ ಅಲ್ಲನಾ ಈ ಪ್ರೊಸೀಡಿಂಗ್ಸ್ all right espera
ಅದೆಲ್ಲ ಹಾಜರು ಮಾಡಿ ಮೊದಲೇ ಸ್ಟೇಟ್ಮೆಂಟ್ ಡಾಕ್ಯುಮೆಂಟ್ ಸೈನ್ ಮಾಡಿ ಆಮೇಲೆ ಅಷ್ಟೇ ಕೊಟ್ಟು ಮತ್ತೆ ಅಟೆಂಡ್ ಮಾಡ್ತಾರೆ.
espera consequently the repetition is allowed. Stop. The impugned proceedings in case number RA YLK 576 of 2021 on the file of the second respondent, Assistant Commissioner, Bangalore North Taluk, is hereby quashed and set aside. Stop. The entries made in column number 11 regarding the said proceedings are also directed to be removed forthwith. Stop. The Tahsildar shall ensure that such entries in column number 11 in respect of the land in question is removed as expeditiously as possible and at any rate within a period of 15 days from the date of receipt of a copy of this order. Okay? Huh? ಅಷ್ಟೇ ತಾನೆ ಆಯ್ತು 4 weeks. ಇದನ್ನ ಮೆಮೊ ಹಾಕ್ಬಿಡಿ. Matter is called out. There is no representation for the petitioner. Stop. Release this matter on 14th of February 2024 to enable the petitioner to furnish certified copy of the auction. Auction proceedings dated 17/9/2021. On 22/1/2024, the following order was passed. Extract monthly. As per matter is called out, there is no representation for the petitioners. Stop. It appears that the petitioners have lost interest in the matter. Full stop. Consequently, the petition stands dismissed for non-prosecution. Yes. What was the direction? 10/1, huh? 33/2022. Allah. That earlier directions were given on 39/2022. ಏನಂತ ಎಂಡಾರ್ಸ್ಮೆಂಟ್ ಕೊಟ್ಟವರು 10/1/2023.
Yeah, I think the only part of the high interest of the working usually
In fact, we had not issued any such direction. The order dated 30/9/2022, we had not issued any direction. Prima facie, this court is of the constitutional opinion that this exercise of identification of the properties was required to be done by the revenue authorities with the assistance of the survey settlement authorities instead of directing the parties to approach the civil court to get the rights declared. Now, we had not issued any direction. Anyway, it's of no consequence. They are huh?
As the occasion, I had no objections on the record.
Huh? Sir, they have got 2 acres of land under a registered sale deed from Govind Rao. What is your claim?
Made before the assistant. Page number 38 of my objections. Right, but it is
38.
R11. Entire the revenue records right from the 1960s, right till today is standing either in my name and my predecessor. Now, a prayer.
Did you have you read the orders passed by this court? Their contention is 4 acres of land were granted to Govind Rao. 4 acres of land were granted to Iramma. You are claiming through Iramma. Their claim is regarding Govind Rao.
What is the prayer in the? They are claiming my land.
Why would they claim your land?
Kindly see the page number 41 prayer. Even in the repetition prayer. Page number 41. Appeal. Pass an order directing the first responding Tahsildar Bangalore North to cancel the RTCs and other revenue entries made in respect of non-existent survey number 77, having staged it in the name of Kuttama, that is in my name. And right of due in the period 1981.
Why are you seeking ಹೌದು ಸರ್, ಅವ್ರದೇ ಬೇರೆ ಲ್ಯಾಂಡು, ನಿಮ್ದೇ ಬೇರೆ ಲ್ಯಾಂಡು. Why are you asking their name to be removed? We are not concerned with the possession, sir. If they are 2 different sets of lands. 4 acres were granted to Govind Rao. 4 acres were granted to Iramma. These are different lands. Their claim is traced to Iramma. Your claim is traced to Govind Rao. There are 2 different lands.
Which are being fragmented and distributed to 12 different persons with different survey number.
Survey number? You know?
We are land targets such as the survey number 77 not to Govind Rao, not to Iramma. That is automatic case.
35.
Survey number 35 Gomara.
ಎರಡೂ ಸರ್ವೆ ನಂಬರ್ 35 ಏನೇ. No. According to you, it is survey number 35 only, block number 3. ಅವ್ರದ್ದು ಯಾವುದು?
different land.
New their survey number from 35 part to new survey number 77. Whereas my status and location is from the 1977.
ಹೌದು
After
ಸರ್,
lapse of 60 years.
ಅದೇ ಬೇರೆ ಪ್ರಾಪರ್ಟಿ, ನಿಂದೆ ಬೇರೆ ಪ್ರಾಪರ್ಟಿ, ಬೇರೆ ದಿ ಕನ್ಫ್ಯೂಷನ್. Why are you asking for that is your prayer before the assistant commissioner? If they are disturbing possession, civil court. You approach the assistant commissioner. You then sir, there are registered documents on either side. ನಿಮಗೆ ಯಾವ ತರ ರಿಜಿಸ್ಟರ್ಡ್ ಡಾಕ್ಯುಮೆಂಟ್ ಇದೆಯೋ ಅವ್ರ ಹತ್ರನೂ ರಿಜಿಸ್ಟರ್ಡ್ ಡಾಕ್ಯುಮೆಂಟ್ ಇದೆ. And they are tracing the claim to Irama. You are tracing the claim to Govind Rao. ಮತ್ತೆ what is the difficulty?
Goes to survey number 77. This is appear the 1980.
80. ಅದರಲ್ಲೇ 77 ಅಂತ ತೋರಿಸಿದ್ದಾರೆ.
ಹೌದು 1995 ಸೈಟ್ ಮೇಲೆ ಬೇಸಿಸ್ ಮಾಡ್ತಾರೆ. 1995 ಬೇಸಿಸ್ ಆಫ್ ಸೈಟ್ is survey number 35 part 3.
Then how did they, when it change to 77? What is this document? $35. Column number?
Column number 3.
ಅದು ಬ್ಲಾಕ್ ನಂಬರ್ ಸರ್, ಅದು ಬ್ಲಾಕ್ ನಂಬರ್ ಇಲ್ಲೇ ನಾವು we have noticed. Block number 3 of survey number 35, 4 acres is granted to Govind Rao. Huh? ಎಲ್ಲಿ? ಎಲ್ಲಾನು ಸರ್ವೆ ನಂಬರ್ 35 ಅಲ್ಲೇ. ಎಲ್ಲಿದೆ 77? ಇಲ್ಲಿ ಸರ್, ಸರ್ವೆ ನಂಬರ್ 35 ಬ್ಲಾಕ್ 3. ಹೌದು, ನ್ಯೂ ಸರ್ವೆ ನಂಬರ್ಸ್ ಅಲ್ಲ ಅದು. No, no, no. Both of them were granted. In fact, all of them, all these persons were granted 4 acres of land each in survey number 35 only. Subsequently, ನಿಮಗ್ ಕೊಟ್ಟಿದ್ದ ಲ್ಯಾಂಡ್ ಅನ್ನ ವಾಟ್ ನ್ಯೂ ನಂಬರ್ ವಾಸ್ ಅಸೈನ್ಡ್, ಅವ್ರಿಗೆ ಕೊಟ್ಟಿದ್ದ ಲ್ಯಾಂಡ್ ಅನ್ನ, ಇರಮ್ ಅವ್ರಿಗೆ ಕೊಟ್ಟಿದ್ದ ಲ್ಯಾಂಡ್ ನ ವಾಟ್ ನ್ಯೂ ನಂಬರ್ ವಾಸ್ ಅಸೈನ್ಡ್ is something that you will have to point out from the records. You can't question all that now, sir. We will not permit you to question that one. You restrict your claim in accordance with the sale deed that you have got. We will continue at 2:30. ಅಲ್ಲ, we have spent so much of time again. ಮತ್ತೆ ನಾಳೆ ಅಂತಂದ್ರೆ ಕಷ್ಟ ಆಗೋದು.
ಒಂದಾಗಿದ್ದೀರಾ ಸರ್? ಒಂದೇ ಆಗಿರೋದು 230ಗೆ ಒಂದೇ ಇರ್ಬೇಕು. ಯಾವ್ದು ಒಂದೇ ಒಂದಾಗಿದೆ.
ತುಂಬಾ ಕಡಿಮೆ ಇಲ್ಲ ಕಡಿಮೆ. ಈಗ ಕಡಿಮೆ ಕೊಡೋದು. ಯಾಕಂದ್ರೆ ನಾಳೆ ಫ್ರೈಡೆ ಪರ್ಸನಲ್ ಬರ್ತದೆ. ಮೂವ್ ಆಗಿದೆ ಅದಕ್ಕೆ ನಾವು ಫೋನ್ ಮಾಡ್ಬೇಕಂತ ಇದಕ್ಕೆ ಸಣ್ಣ ಮತ್ತೆ move ಮಾಡಿ ಮತ್ತೆ ಹಾಗೆ ಕೊಡ್ತೀನಿ ಮತ್ತೆ ಬೇಗ ಕಟ್ಸ್ತಾ ಇದೆ. ಈಗಿನ ಮಟ್ಟದಲ್ಲಿ ನೀವು ಬರೋದು ಅದನ್ನೇ ಹೇಳೋದು. ನಾನು ಮಾತಾಡ್ತೀನಿ, ನೀವು ಕಟ್ತಿದ್ದೀರಿ ಅಂತ ಅವೆಲ್ಲರೂ ಕಾನ್ಫರ್ಮ್ ಮಾಡಿ ಕೇಳಿ ಅದೇನ್ ಕಳಿಸ್ತಾರೆ ಕೇಳಿ ಕೇಳಿ ಹಿಂಗೆ ಹೇಳೋದು ಎಲ್ಲರೂ ಆನ್ಲೈನ್ ಬರ್ತಾರೆ ಎಲ್ಲರೂ ಪ್ರಮಾಣ ಅಂತ ಹೇಳೋದು. ಹಾ
What up, sir? Sir, serial number 34 ಅಲ್ಲಿ ಹಲೋ
ಹೇಳಿ ಸರ್, ಕೇಳಿಸ್ತಿದೆ.
ಕೇಳ್ತಾ ಇದೆಯಾ ಈಗ?
ಹೇಳಿ ಸರ್.
ಅದ್ರ ಜೊತೆಗೆ ಸೀರಿಯಲ್ ನಂಬರ್ 34 ಜೊತೆಗೆ ಇನ್ನೊಂದು ಸೇಮ್ ಆರ್ಡರ್ ನೇ ಚಾಲೆಂಜ್ ಮಾಡಿದ ಒಂದು WP ಇದೆ. ಒಂಚೂರು ನೋಟ್ ಮಾಡ್ಕೊಳ್ಳಿ, ಹೇಳ್ಬೇಕಾಗುತ್ತೆ ಅಂದ್ರೆ 12154.
Only state. Serial number 33 at the request of learned counsel for petitioner. Release this matter on 7th of February.
Serial number 31. Check it.
Go place this information. This endorsement issued by the Assistant Director of Land Records. Huh? What is this? You have sought for issuance of a copy of the Akarban Mula Tippani Karda in respect of survey number 77. Huh? ಏನಂಗಂದ್ರೆ ನಾಟ್ ಅವೈಲಬಲ್ ಅಂದ್ರೆ ಅರ್ಥ ನಾಟ್ ಅವೈಲಬಲ್ ಅಂದ್ರೆ ಹೆಂಗ್ರಿ ಅರ್ಥ ಅದರಂತೆ ದಾಖಲೆಗಳನ್ನು ಪರಿಶೀಲಿಸಲಾಗಿ ಸರ್ವೆ ನಂಬರ್ 77ರ ಆಕಾರ್ ಬಂದ್ ಮೂಲ ಟಿಪ್ಪಣಿ ಮತ್ತು ಕರ್ದ ದಾಖಲೆಯು ಲಭ್ಯವಿರುವುದಿಲ್ಲ ಕಾರಣ ನೀವು ಕೋರಿರುವ ನಕಲು ವಿತರಿಸಲು ರಹವಿರುವುದಿಲ್ಲ ಅಂದ್ರೆ ಅರ್ಥ ಹೌ ಕ್ಯಾನ್ ಈ ಸೇ there is no ಆಕಾರ್ ಬಂದ್ no ಕರ್ದ no ಮೂಲ ಟಿಪ್ಪಣಿ ಅರ್ಥ ಅಲ್ಲ for what purpose have you furnished this information?
Authority says. Relying upon separate document. That document itself is not available. That is what the authority.
ಅಲ್ಲ ಏನು see neither you can tell anything about their acquisition of title nor they can say anything regarding acquisition of your title. What are you trying to do before the revenue authorities? Huh? You approach the assistant commissioner saying you please delete their name and to enter your name, is it? Your name is not entered in terms of the sale deed that you purchased? Huh? So, sir, therefore, if the dispute is regarding identification of the property and to say who is in possession of the property, you will have to go before the civil court. Merely because you file an appeal under section 136(2), you will first of all not get a jurisdiction to go and file such an appeal. Revenue entries are maintained only in terms of the registered documents. ಆಯ್ತು ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿದೀರಾ ಏನು what do you find out about with that? ಅಂದ್ರೆ ಅವರ ಇದಕ್ಕೆ ಬೇರೆ ನಂಬರ್ ಕೊಟ್ಟಿರ್ಬೇಕು ಅಲ್ವಾ? ಸಿ ಪ್ರಾಪರ್ಟೀಸ್ ಆರ್ ಟೂ ಡಿಫರೆಂಟ್. As we found in the morning session, you are tracing your title to Govind Rao. They are tracing the title to Iramma. That document is that you pointed out, a list of the grantees. ಅದರಲ್ಲಿ ಗೋವಿಂದ ರಾವ್ ಅವರ ಹೆಸರು ಇದೆ, ಈರಮ್ಮ ಅವರ ಹೆಸರು ಇದೆ. ಹಾ
Last page. In 77 the word also 77, 76, 77 on top. And again 77, 78 the you see a mission.
ಏನು ಎಲ್ಲೋ ಮೇಲ್ಗಡೆ ಬೇರೆದಲ್ಲಿ ಯಾವ್ದು ಏನೋ ಒಂದು ತೋರಿಸಿದ್ದಾರೆ. ಏನು ವಾಟ್ ಡು ಯು ಫೈಂಡ್ ಔಟ್ ವಿತ್ ದಿಸ್? These are all new numbers. New numbers. Ah.
78, 79, chronologically.
Ah.
That 77 belongs to me.
Ah.
Whereas 77 and 76 are shown in a different block, which has been exhibited in the top.
ಏನದು ಸಂಬೇರ್ ಅಲ್ಲಿ ಎಲ್ಲೋ ಬೇರೆ ಕಡೆ ಮೇಲ್ ತೋರ್ಸ.
Has to be identified with two 1942 first order. It is not has to identify the land and all of it. It is a connected matter. 35/4 and the 35/5. We accept the commissioner has stated in the connected matter in the notice for the issue, notice, in which he has stated, survey number 78 is old survey, old number 35/4. And
ಈ ಆಕಾರ ಬಂದು. Where is this? You said no, what the endorsement issued is incorrect. ಆಕಾರ ಬಂದು ಟಿಪ್ಪಣಿ ಕಾಪಿ ಎಲ್ಲ 47.
Number 77, copy has been submitted. Okay, there is no copy available.
This is block number 3.
Block number 3.
Huh? Assigned new number 77. So in respect of this property, your name is found in the land record? It's not found. How is it that your name is not entered in the land record?
No, what happened? I filed an application purchasing from Odisha. If the application and all these things have not been done by this purchasing. Second, when they approach the thing, these people are very counterclaim. In the papers of practice, the revenue department, the harm. Connected matter. They say 35/4 has become 78. 35/6 has become 79.
Yes, it itself is 75.
Any instructions you have? Every block is assigned a new number. ಇದು ಅವಾಗಲೇ ನೀವು ಒಂದು ತೋರಿಸಿದ್ರಲ್ಲ ಡಾಕ್ಯುಮೆಂಟ್ ಯಾವ್ದು ಹೇಳಿ? ಅದು ಇದರಲ್ಲಿ ಈರಮ್ಮ ಅವ್ರ ಹೆಸರು ಇಲ್ವಲ್ರಿ in this document?
I have a grant.
Huh?
I have to do the grant to the side. Page number 9. Page number 10. I can have it.
This cannot be disputed.
It's disputed by the very authorities itself.
Huh?
Building authorities itself. So my objection, the revenue very authority says the original. They are processing to rebuild the all the 50 copies. This is comes within others, Page number 2. Page number 2, paragraph 2. ಅರ್ಜಿದಾರ ಮನವಿ ಕುರಿತು ಮೀಸಲಹಳ್ಳಿ ಗ್ರಾಮದ ಆ ಮೂಲ ದಾಖಲೆಗಳನ್ನು ಪರಿಶೀಲನೆ ಸರ್ವೆ ನಂಬರ್ 35ರಲ್ಲಿ 75, 76, 77, 75
ಆಯ್ತು 85.
75 ಹೊಸ ನಂಬರ್ ಆಗಿರುವ ಎಲ್ಲಾ ಟಿಪ್ಪಣಿ ಸ್ಕ್ಯಾನಿಂಗ್ ಪತ್ರಗಳು ಮಾತ್ರ ಲಭ್ಯವಿದ್ದು ಮೂಲ ಎಲ್ಲಾ ಟಿಪ್ಪಣಿ ಪಕ್ಕಾ ಪುಸ್ತಕಗಳು ಮೂಲ ಗ್ರಾಮದ ಆ ದಫ್ತರಲ್ಲಿ ಲಭ್ಯವಿರುವುದಿಲ್ಲ ಹಾಗೂ ಈ ಕಚೇರಿಯ ಲಭ್ಯವಿರುವುದಿಲ್ಲ.
ಸ್ಕ್ಯಾನಿಂಗ್ ಪ್ರತಿಗಳು ಮಾತ್ರ ಲಭ್ಯವಿದ್ದು ಮೂಲ ಎಲ್ಲಾ ಟಿಪ್ಪಣಿ ಎಲ್ಲಾ ಪಕ್ಕಾ ಪ್ರತಿಗಳು ಮೂಲ ಗ್ರಾಮದ ದಫ್ತರ್ನಲ್ಲಿ ಲಭ್ಯವಿರುವುದಿಲ್ಲ.
ಹಾಗೂ ಈ ಕಚೇರಿ ಅಭಿವೃದ್ಧಿ 75 81 ಗ್ರಾಮದ ನಕಾಶೆ ಲಭ್ಯವಿರುತ್ತಿಲ್ಲ. ಈ ಕಚೇರಿಯ ಆಕಾರದಲ್ಲಿ ದುರಸ್ತಾಗಿರುವ ಬಗ್ಗೆ ದಾಖಲೆಗಳನ್ನು ತಯಾರಿಸಿ ತಾಲೂಕು ಕಚೇರಿಗೆ ಕಳಿಸಿರುವ ಪತ್ರವನ್ನು ದೃಢೀಕರಿಸಲು ಅಗತ್ಯವಿದೆ. ಜಮೀನು ದರಖಾಸ್ತು ಮೂಲಕ ಮಂಜೂರಾದ ಜಮೀನಿನ ಬಾಬ್ತು ಆಕಾರ ಬಂದಂತೆ ಗ್ರಾಮದ ಆಯ್ಕೆಯರು ನಂಬರ್ 74 ಆಗಿದ್ದು 75, 82 ಆಕಾರ ಬಂದಿರುವುದಿಲ್ಲ. ಉಲ್ಲೇಖ 4ರಲ್ಲಿ ಪತ್ರದಲ್ಲಿನ ಸೂಚನೆ ಇದೆ. ದಿನಾಂಕ 9/12/2020 ಸದರಿ ಗ್ರಾಮದ ಗ್ರಾಮ ನಕಾಶೆ ಮತ್ತು ಆಕಾರ ಬಂದಿದಂತೆ ಗ್ರಾಮದ ಆಯ್ಕೆಯರು ನಂಬರ್ 74 ಆಗಿರುತ್ತದೆ. ಪ್ರಸ್ತುತ ಅನುಕ್ರಮೆಯಂತೆ 75ರಿಂದ 85ರವರೆಗೂ ಕಾಣೆಯಾದ ದಾಖಲೆಗಳ ಪುನರ್ ನಿರ್ಮಾಣದ ಬಗ್ಗೆ ಪ್ರಸ್ತಾವನೆ ಸಲ್ಲಿಸಬೇಕಾಗಿತ್ತು. ಜಾಲ ಹೋಬಳಿಯ 18 ಗ್ರಾಮದಲ್ಲಿ ನಶಿಸಿ ಹೋಗಿರುವ ದಾಖಲೆಗಳ ಪೈಕಿ ಜಾಲ ಹೋಬಳಿ ಮೀಸಲಹಳ್ಳಿ ಗ್ರಾಮವು ಸಹ ಸೇರಿರುತ್ತದೆ. ಮುಂದುವರೆದು ಸರ್ವೆ ನಂಬರ್ 35ರ ಪೈಕಿ ದುರಸ್ತಾದ ಹೊಸ ಸರ್ವೆ ನಂಬರ್ 85 ಮೂಲ ಎಲ್ಲಾ ಪಕ್ಕ ಆಕಾರ ಲಭ್ಯವಿಲ್ಲದಿರುವುದರಿಂದ ಮಾನ್ಯ ಜಿಲ್ಲಾಧಿಕಾರಿಗಳ ಅಧ್ಯಕ್ಷತೆಯ ಜಾಲ ಹೋಬಳಿ 18 ಗ್ರಾಮದಲ್ಲಿ ಕಾರ್ಯಗಳ ಮೂಲ ದಾಖಲೆಗಳ ಪುನರ್ ನಿರ್ಮಾಣ ಮಾಡುವ ಬಗ್ಗೆ ತೆಗೆದುಕೊಂಡ ತೀರ್ಮಾನದಂತೆ ಉಲ್ಲೇಖ 7, ಉಲ್ಲೇಖ 8 ಸರ್ಕಾರಗಳ ಸೂಚನೆಯಂತೆ ತಹಸೀಲ್ದಾರ್ ಯಲಹಂಕ ರವರಿಂದ ಮಂಜೂರಾತಿಯ ನೀತಿಯನ್ನು ಪರೀಕ್ಷಿಸಿಕೊಂಡು 75ರಿಂದ 85 ಎಲ್ಲಾ ಟಿಪ್ಪಣಿ ಪಕ್ಕಾ ಪುನರ್ ನಿರ್ಮಾಣ ಮಾಡಬೇಕಿತ್ತು. ನಿಯಮಾನುಸಾರ ಅಗತ್ಯ ಕ್ರಮ ಕೈಗೊಂಡು ಈ ಕಚೇರಿಗೆ ಪೂರ್ವ ಪ್ರಸ್ತಾವನೆಯನ್ನು ಸಲ್ಲಿಸಲು ಆದೇಶಿಸುವುದರಿಂದ ಅಗತ್ಯ ಕಾರ್ಯಗಳಿಗೆ ಆಕಾರವನ್ನು ಪುನರ್ ನಿರ್ಮಾಣ ಮಾಡಲು ತಮ್ಮ ಸ್ಪಷ್ಟ ಅಭಿಪ್ರಾಯದಲ್ಲಿ ಈ ಬಗ್ಗೆ ಸ್ಪಷ್ಟೀಕರಣ ನೀಡಲು ಹಾಗೂ ಉಲ್ಲೇಖ 7ರಂತೆ ಸರ್ಕಾರ ಸುತ್ತೋಲೆಯ ಪ್ರಕಾರ ಮಂಜೂರಿ ಜಮೀನನ್ನು ದುರಸ್ತಿಪಡಿಸಲು ಮಂಜೂರಿಗೆ ಸಂಬಂಧಿಸಿದಂತೆ ದೃಢೀಕೃತ ನಕಲನ್ನು ಭೂ ಮಂಜೂರಾತಿ ಆದೇಶ OM ಸಾಗುವಳಿ ಚೀಟಿ ತಾಲೂಕಿನ ನಿರ್ದಿಷ್ಟ ಅನುಮೋದಿತ ರೆವಿನ್ಯೂ ನಕ್ಷೆ ಓದಿ ಸಂದಾಯಗಳ ಸಂಖ್ಯೆಯಲ್ಲಿರುವ RTC ಮತ್ತು ILO RR ದಾಖಲೆಗಳನ್ನು ದೃಢೀಕರಿಸಿ ಪ್ರಸ್ತಾವನೆಯನ್ನು ಸಲ್ಲಿಸಲು ಕೋರಿ ಈ ಕಚೇರಿಯ ಪತ್ರದ ಕ್ರಮ ಸಂಖ್ಯೆ 19/2/2020 ಪತ್ರ ಬರೆದಿದ್ದು ತಹಸೀಲ್ದಾರರಿಂದ ಕರಾರು 4 ಮಂಜೂರಾತಿಗೆ ಪ್ರಾಪ್ತು LNT ಸೋಂತೆ ಮೂಲ ದಾಖಲೆಗಳನ್ನು ಲಭ್ಯವಿದ್ದು ವರದಿ ಸಲ್ಲಿಸಿರುತ್ತದೆ. ಈ ಕಡತವನ್ನು ಭೂಮಾಪಕರಿಗೆ ವಿತರಿಸಲಾಗಿ ಭೂಮಾಪಕರು
This communication is given by the Assistant Director of Land Records.
No, the entire survey number so far as 75 to 85 is concerned. Entire survey records is being rebuilt. Even now, whatever the document they have filed just before this court. Even that there is a reference of rebuilding by you. Today they have filed with the letter dated 1/2/2023, page number 3. There is a reference to this letter.
Page number
1/2/2023. ಅದರಲ್ಲಿ ಈ ಕೆಲಸದಿಂದ ಮೂಲಕ ತಿಳಿಸಿಕೊಡುತ್ತಿದ್ದರೆ ಯಲಹಂಕ ತಾಲೂಕು ಜಾಲ ಮೀಸಲಹಳ್ಳಿ ಗ್ರಾಮದ 78 ಮತ್ತು 79ರ ಪಾಕ್ತು ಉಲ್ಲೇಖ ಭೂಮಾಂಕ ಪ್ರಕರಣದ ಪರಿಶೀಲಿಸಿ ಸೂಚನೆಗೆ ಕ್ರಮ ಕೈಗೊಳ್ಳಲು 20 ಸರ್ವೆ ನಂಬರಲ್ಲಿ 35 ದುರಸ್ತಿಯಾಗಿರುವ 35ರಿಂದ 85 ದಾಖಲೆಗಳನ್ನು ರದ್ದುಪಡಿಸುವ ಬಗ್ಗೆ ಪ್ರಾಧಿಕಾರದಲ್ಲಿ ಸ್ವಯಂ ಪ್ರೇರಿತ ಮೇಲ್ಮನವಿ ಪ್ರಸ್ತಾವನೆ ಸಲ್ಲಿಸಬೇಕಾಗಿರುವುದರಿಂದ ಇದರಲ್ಲಿ 75ರಿಂದ 85 ಮತ್ತೆ it is the process of entire the rectification. They said the new number was assigned in 81. Whereas revenue records RTC are coming from the year 1969-70 at page number 82. record is earlier to 81. What they are claiming? They are claiming new survey number was obtained in the year 81. How could a survey, the RTC revenue records come to mind in the year 1969? Page number 38, page number 82, along with my application, I produced the RTC where for 1969 they admit in their appeal before the Assistant Commissioner also, yes, revenue records are there in their name from 1969. They do not challenge any mutations in these entries where I got it under survey. Just they file an appeal saying that move the entry. They do not, for the last 65 years, they do not challenge any of the mutations. An appeal under the 136 can be filed only if it is an agreed by some order. After 65 years, without continuation of delay, he files an appeal, just an appeal, without challenging any mutations in my favor. And is already converted at page number 18. I've sold the property and converted.
Huh?
This property is already sold to by me to one Nagaraja. I stated in my intention. And it's been converted there.
After purchasing from you, he has got it converted.
Here, page number 11 of my application, the IL and RR, survey number 77, the name of the grantee and the subsequent purchaser Akkayama name shown. Page number 11 of my application.
Statement of objections.
Objection. Statement of objection.
Of respond number 3C. 3? Avarena?
Page number
11.
Objection R. Seven. Left side, survey number. Thereafter, the purchaser name Akkayama name is shown. But Akkayama purchases the property in 1964. Thereafter, there was one more sale deed which is executed in the year 1980, of which there is a reference on page number 18, where I have referred the survey number is of 77.
So there were mutation entries
based on the sale deed and also on the based on the fact.
even before 1964, according to you. If that is the case, how is it that you are identifying this very land? Sorry, you have approached the assistant commissioner saying, no, iವ್ರಿಗೆ ಮಾಡಿರೋದು revenue entry, mutation entry ತೆಗೆದಾಕಿ ಅಂದ್ಬಿಟ್ಟು. How is it that you are so clear? Lala, see, the problem is from the year 1964 or even prior to that, there are mutation entries. Sir, let us not come to the podi. According to the statement of objections, the land that was granted, 4 acres, which was granted in favor of Iramma, she sold it in favor of Akkayamma in the year 1964. 1964 in the, there are revenue entries. ಇರಬಹುದು. How are you concerned with that?
As on today,
application.
Hmm.
Only my application, after application to consider, my application was not considered by the state commissioner. And due to that, I have.
When did you purchase the land? 95. And you approached the Tahsildar for mutation. When? You purchased the land from whom? Govindrao. Govindrao's son. His name was entered in the land records? Huh? In respect of 4 acres?
4 acres, out of 4 acres, 2 acres I have to take. And getting the page. Section B, page 24.
ಮೂವತ್ತೈದು ಬಾರ್ 3. ಇವರು 35/4.
Our revenue records are standing.
No, yours is block number 4. Giramma was given block number 4. His was block number 3. So they were adjacent lands. 4 different 4 acres each, adjacent to each other.
24 acres. There are so many acres, not different persons in this position.
ಹೌದು.
Because that I am also one of the friends.
ಗೋವಿಂದ್ರಾವ್. ಹೌದು.
Govindrao, I have. Govindrao 4 acres, I have purchased
2 acres.
Another 2 acres, take the 2.
Yes.
The issue is my 2 acres, I only take 2 acres. Whereas 4 acres, I need to 4 acres. Whereas in their case, 3 acres 9 good. And the something without Khara, and even the.
Allala, how is it that the 2 issues have
Not I am sure one document 77 are visible, because that is the issue now. Because the actual director of land is not has to identify the appropriate land. So see my number submission, because according to them, some documents are available, some documents. Ultimately, copies have been given to us, endorsement is given to.
how is it, what is this they are saying all records are lost. When did it get lost? Scanned copies prakara, is there any difficulty to identify the 2 pieces of land? Why are they saying no ಮೂಲ ದಾಖಲೆಗಳು ಲಭ್ಯ ಇಲ್ಲ, ಆದ್ರಿಂದ we have to rebuild the file? If scanned copies are available, and if they are able to identify that these 2 are different pieces of land.
They say 1981 new survey number is assigned, whereas my revenue records goes to 1973-74. If that their version of the scan copy is available, the new number was assigned only in 3/8/1981. Then revenue records cannot stand in my name from the 1973-74. Even those the records, whatever it is a body record, the alleged relayed by my learned friend, is also become the discrepancies because of the revenue records is existing in my name prior to the alleged date of 1980.
Why are you apprehensive? See, you
they are seeking to move my entries from.
ಅವ್ರು ಏನಾದ್ರು ಹೇಳಿ.
I'm not waiting for them to identify.
Why are you apprehensive? Just because we said why we can't find out from the scanned copies, you are already expressing apprehension. Why?
I said the discrepancies in the scanned copy just like me.
You know that
because they whatever they produce with the copy scan. That says the date is of 3/8, new number was assigned on 3/8/1981. Whereas revenue records stand in 1977. Sorry.
According to the initial register, there are 60 different areas in survey number 35. Survey number 35, there are 60 different areas. Not we alone are here. And all these things have to be, survey number 35. It has to be. All these according to the revenue record, they have already there. There is a document of 70 different persons, including myself. 20 different persons. All these have to be explained. That's only there are two surveys, the same document. Here, there are 70 different individuals who are actually, who these are part of that is 35. Also, I have these survey of the entire survey number.
We will ask the deputy registrar, deputy director of land records to furnish all the survey records in respect of survey number 35, old survey number 35. Let him produce all that. 35. Entire survey number 35. All the records that are available in the office of the survey department, let it be produced. Huh? And let him submit a report as to how after the grants were made, how many grants were made, what information they received, how it was coded, how the new number was assigned. All that information should be available with them. Huh? And this statement, I don't know how they are saying that, how it got lost. Whether the records of the survey department was lost or the records of the revenue department. See, there are two different offices. Survey settlement office is here in care circle. The taluka officers, which are headed by the tahsildars, they will be having the revenue records. Huh? How is it that the assistant director is saying that the revenue records in respect of Jala Hubli was lost at what time point of time? We can get information from the revenue authorities also regarding the grant. ಯಾರ್ಯಾರಿಗೆ grant ಮಾಡಿದ್ರು, because the original grant register will be there. Alva. Survey records are different. They will be maintained by the in the office of the commissioner. Survey settlement. Whether it is so difficult to correlate the two things. Huh? ಬರ್ಕೊಳ್ಳಿ.
These are the entire 75 to 80. Last day.
ಅದೆಲ್ಲ ಏನು ಬೇಡ. First let us get the information as to what exactly has happened to the records. On hearing the learned senior counsel for the petitioner and the contesting respondents, and the learned counsel for the contesting respondent, come on. It appears that In the list of the grantees, the name of Srimati Iramma is not found. So, this is a document of the year 1981.
Survey authorities document. It's not revenue department. It's a survey document. A scanned copy of the available, what they are telling you survey. With respect to the ID, that respect, not with respect to the list of brands.
So, ಈ ಡಾಕ್ಯುಮೆಂಟ್ ನೀವು ಇದರಲ್ಲಿ is it there on record? ಅಲ್ಲಲ್ಲ on record. Where is it? Which page? Huh?
There was a ruling with respect to survey number 35/3. 35/3. New survey numbers being assigned. Only to that extent they are available. This is not concerned with the entire list of other things of survey.
ನೋಡಿ ಸರ್ ಅದನ್ನು.
Survey document. Survey.
Huh?
This is
ಯಾವ್ದಾದ್ರಾಗ್ಲಿ, whether it is survey or the revenue document, revenue authorities, there is a list of all the grantees, block number ಕೊಟ್ಟಿದ್ದಾರೆ, to whom it was granted ಅಂತ right side ಅಲ್ಲಿ ಇದೆ. According to this document, block number 3 is 4 acres is granted to Govindrav. Block number 4 is granted to Kamla Bai, not to Iramma. ಯಾವ್ದಾದ್ರಾಗ್ಲಿ, ಹೆಂಗಾದ್ರಾಗ್ಲಿ, it is in respect of survey number 35. ನಿಮ್ದು survey number 35. Huh? How is it that name of Iramma is not here?
All list of, there are more than this, more than 100 grantees are there.
In survey number 35.
This is only with respect to
We'll see. Yes. ಏನ್ ಹೇಳ್ದೆ?
That in the list of grantees, the name of Irama is not found. This is the document of year
81. According to the learned senior counsel appearing for the petitioner. So, however, according to the learned counsel for the contesting respondents, this information is not the complete information of all the grantees in survey number 35. ಯಾವ village? In Misaganahalli of Jala Hobli. So, next para. On the other hand, some information is forthcoming from the Assistant Director of Land Records that since the survey settlement records were destroyed, survey settlement records in respect of Jala Hobli were destroyed, there is a direction to rebuild the same. Stop. Next para. The learned HCDP is hereby directed to secure the original grant register. In respect of survey number 35 of Misiganahalli, Jala Hubli, and the survey settlement records from the office of the Commissioner, survey settlements. So, the concerned officers shall brief the learned HCGP regarding the records maintained by the concerned authorities, more particularly the Department of Survey Settlement, regarding the entries made in the survey settlement records consequent to the grant made to several persons in survey number 35. Semicolon, the Podi and Durast and assignment of new numbers in respect to the various pieces of lands that were granted in favor of various persons. Full stop. Next para. Release this matter on 14th of February. Learned counsel for the petitioner submits that the deficit court fee has been paid in the office this morning. Stop. Office to verify. Yes. Huh? Second application. Page number 52. Two 2022. Who is this applicant? Withdrawing the application filed under section 122 capital A to review the which order?
Because UPA holder, this is the right of original applicant. They were issues since GPA does not have.
You are challenging which order now? 15. To strike out the name of the you are Tukaram Shetty. Andre, you are a landlord. How will you be the respondent there? Huh? 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 ಅಲ್ಲಲ್ಲ ಒಂದ್ ನಿಮಿಷ ದಾಸಪ್ಪ was the original applicant. How are you related to him? Brother's son. Who filed application? Hmm. You entered impleaded. So that order was reviewed and his name was put back. You are agreed of that order. All. Learned HCGP takes notice for response number 1 and 2. Issue notice to response number 3 to 9. Learned counsel for the petitioner is directed to serve a copy of the petition along with annexures on the learned HCGP. Let them come, we'll see. No. Yes. That should be taken. Recused R4. Post Sara, refuse on the petition. Respond number 4. ಅಲ್ಲ ಕೋರ್ಟ್ ನೋಟಿಸ್ ಹೋಗಿಲ್ವಾ? ಏನಾಯ್ತು ಅದು?
In this matter, I am for the R5, my lord. I have filed wakalat for R5, serial 34.
Do you want to appear for respond number 4?
No, my lord.
Respond number 4. ಕೋರ್ಟ್ ನೋಟಿಸ್ ವಾಪಸ್ ಬಂದಿ ನೋಡ್ರಿ. ಬಂದಿಲ್ಲ ಈಗ. ಎಲ್ಲಿ ರೆಕ್ಯೂಸ್ ಅಲ್ಲ, ಇವ್ರು ಹ್ಯಾಂಡ್ ಸಮನ್ಸ್ ರೆಕ್ಯೂಸ್ ಅಂತ ಬಂದಿದೆ. ಯು ಪ್ಲೀಸ್ ಟೇಕ್ ಔಟ್ ನೋಟಿಸ್. The petitioner is directed to take out fresh steps for service of notice on respond number 4. ಅದಕ್ಕೆ ಮುಂಚೆ the learned counsel for the petitioner submits that he has filed a memo dated 23/8/2023 along with the covering letter and submits that the fourth respondent has refused to receive the hand summons. Full stop. Next para. The petitioner is directed to take fresh steps for service of notice on respondent number 4.
My
Please
lord,
take-
may I make a submission? My lord? Another
Yes.
one, WP 12154 is also filed, my lord. Same order, 12154 of 2022.
This matter along with the WP number 12154 of 2022. Otherly, this respondent number 4 is is he represented?
No, not it represented, my lord.
Ah,
It was for office objections.
All right, all right. Yes.
230 PM matter. Tonight's. Number 11.
Ah.
And then taken over without compensation. As it is also. Consider the compensation. What are the-
The land granted to the government, the KVs, and which only they are coming.
That is their land. That's what they are saying. Without acquisition, it has been handed over to you.
Compared to it. Survey number 1, this is consists of 22 acres. Without naming the specification, it is simply about 1 acre. This exact comment of my order. I have no objection to KPC setup, but I have given up that. I now say, well, at least get compensation, but that also they can't. And KPC cannot have a objection.
Huh? ಇರ್ಬೋದು. But who asked you to hand it over to them? ಅದೇ ರೀ.
In survey number 1, this is consists of 20 acres, without specifying the boundaries. They say in the survey number 1, that 1 acre 5 untas. Obviously, when they comment on how the states would stand there, the citizen would has lost his land without acquisition.
At least they should say, all right, we'll find out from the records whether the land belong to this person. If that is so, then we will recommend to the government to give compensation. ಅದನ್ನ ಹೇಳೋದ್ ಬಿಟ್ಟು ಇಲ್ಲ ಗೊತ್ತಿಲ್ಲ ನಮ್ಗೆ ನಾವು ಹ್ಯಾಂಡ್ ಓವರ್ ಮಾಡಿದೀವಿ ಅಂದ್ರೆ ವಾಟ್ ಇಸ್ ದಿ ಮೀನಿಂಗ್? You are still putting up the construction. Huh? Then what? If they are entitled to, then you will have to give them that compensation. We have directed you to secure instruction, seeking compensation.
Yes, yes. KPTC has deposited the amount. Obviously, that request will be transferred.
On the previous date of hearing, this court had directed the learned AGA to secure instructions from the respondents, more particularly the state and the deputy commissioner, as to whether the contention of the petitioner that their lands have been utilized for the benefit of the respondent KPTCL at the instance of the state without acquiring the land. So, learned AGA submits that the deputy commissioner learned AGA seeks for some more time to secure instructions and make submissions. Full stop. Next para. The learned counsel for the respondent KPTCL submits that the corporation has deposited a sum of rupees 34 lakhs 65,000 with the state for getting the land granted for the purpose of construction of a substation. Full stop. If that is so, the deputy commissioner has to verify from the records and state as to whether the land, the substation has now been set up on the property belonging to the petitioner. Full stop. If that is so, then recommendation will have to be made to the state government to pay compensation to the petitioner. Full stop. Next para. Release this matter on 14th of February.
The only problem which now they have come from some of the board in 2019, they were able to unearth the document. This is a connection. Based on that, they will
Yes.
immediately take the fact.
Yes, yes. Now you yourself have issued that document. Yes. 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 They have stated so. In their petition, they have stated so. Yes. Yes.
But the Google map, which I have taken with the survey.
Dr. Kendisi, the imaging I have produced. Marking the entire comparative of the right hand side water markers, white color, is the part which leads to the account. What the guiding comes to the third document is the village map. The blue portion is the account. In between is 112. This portion indicates that the correction between 112 and the account. What can you do the next document, the second one which I produced, which is the material Pakka, which indicates that every survey number sketch is shown, and this is the sketch of 112. What can you appreciate this fact that this village map is of year 1890. Survey number brought into this particular piece of land was done in 1896. It is not that any resurvey has been done and subsequent to the last edition is not asked me as to how will Nala will be.
Correct. Usually.
Yes, but I don't understand. As in 1890, when the village map was prepared, that is when the survey number 112 has been assigned to this particular piece of land. The Pakka book which is done in the somewhere in the year 1930, the date is not indicated. But my instructions are that the year 1930, the Pakka book was scheduled.
Also, we see that the village map, Rama, which produced
112.
112.
ಎಲ್ಲ ಕನ್ಸ್ಟ್ರಕ್ಷನ್ಸ್ ಇದೆಯಲ್ರಿ?
That is Delta colony. Delta colony more above. That is not my portion. The portion of 3 acres and all retained by Gopal Das Wadhwa, my vendor. And in fact, in my sale deeds, in my boundaries, it specifically says VK survey number 100 Delta colony. Correct.
Have you given a copy to the?
Yes, sir.
What I have produced before a lordship would all is all the more 45. By the very village map, which my learned friend has just now produced. Kindly cannot juxtapose that Google map, which I have produced, with the village map. Now, my lords, village map indicates what are the lines indicating. You can also to see my property is marked in yellow. According to that, this is 112. It may be a bit more, bit less. My lord gets it in yellow color.
ಯಾವ ಇದು ವಿಲೇಜ್ ಮ್ಯಾಪ್ ಅಲ್ಲ?
Village map, how it is good. Now, my lord, my map, there is absolutely no mention of.
Yellow na? Where is the yellow marking?
I don't know, my kids will be in yellow, I don't
I,
know.
the yellow copy is yellow, whatever mark is that is the.
I should just pass on, my lord, what I pass.
112 mark not.
ಕೊಡಿ.
But otherwise, some difficulty in the. Take it from one single thing. 112 ಅಂತ ಏನೇನು ಕೊಡ್ತೇವೆ ಅದು ವಿಲೇಜ್ ಮ್ಯಾಪ್ ಪ್ರಕಾರ 112 not to kind of compare with village map ಅಂತ ಹೇಳ್ತೀವಿ. It's not 112. Can you see the village map? Other point the village map is indicated as 112 in this stage. On this Google image.
No, even according to you, this entire stretch is 112. This entire stretch is 112, even according to you. You have marked this.
Not the top portion.
Illa. It includes. You please see your
Can you see
112.
Village map is 105. There is a clear indication. 105 starts from the left hand side, goes to the right hand side. Below that there is a demarcation. After that 112 starts. Idರಲ್ಲಿ ಆ demarcation ತೋರಿಸಿಲ್ಲ. The entire 105 portion of 105 is also indicated as 112. Just go it again.
No, be the lesson there, Lord. Whatever it is, insofar as what is marked in yellow is exactly 112. So what will also do is, let me assume that there is some inaccuracy insofar as the map over the recording of 112 in the Google map. And the remaining extent as indicated, there is tallies with what is shown in the village map. 112. Now that 112 allows kind of notice. What are the extent of properties shown and how it is indicated is there in the village map? Nowhere in the village map it even remotely indicates an ala or flow of water. What is flow of water or hala? You can also to see the index on the left hand side. Would indicate hala is there on the bluish waving is there. And the yavu nandu. So therefore, they're claiming that it is the hala falls to the ground. And the very fact that the Google map also does not even remotely indicate that there is a nala is out of question. More particularly when there are huge constructions in 112 and 118, which is called the Janta colony. You can also to see in my savings executed by Vadwa, page 65, 64 in the boundaries. You can also to see. And my repetition, page 60, page 64. So another Nero, how does it flow at all? And if it is a nala, why is it the government did not take any action allegedly when constructions have been put up in the remaining extent of land? I can see page 64 on the boundaries as described from my side.
And say village map there is a like area overflowing of the river or the water from the village tank also come and accumulated another code at the bottom portion.
So there are two things now. One, a copy of the order passed by the land tribunal, a special deputy commissioner for enhanced abolition has been produced. That order has not been questioned. It has attained finality. But on the previous occasion, it was contended that there is no such order, and on that basis, the writ petition was disposed of. Now, you yourself have furnished a copy of the order. And although you are pointing out to some change in the ink in one or two lines, that hardly makes any difference, because it does not materially alter or try to tinker with the substance of the order. That portion of the ink where there is a change ink, it only mentions the statute as well. Yes.
The annexure B, which was underlined now says that 2019 they have they will be given hands on and then they will come to this. Not the kind of page number 102 plus. Page number 5 of the order path to the extension 3931 annexure 11. This is
Page number?
102. 5 of the order. The example of disarmament of the coordinate and beginning 2012. Subsequent to the order which is how we relied upon. An endorsement of the issue dated level 690. Not the 5 years it is number 5. Not the fact that the order was not available to the coordinate bench at that point of time. But an endorsement was issued as of level 668. The reason I am making this, if you not kindly see annexure B, annexure B dates to have been issued as on 3rd of 23rd of May 1968. This endorsement which was observed by the coordinate bench not with the level 668. Now the discussion and the findings given by this honorable court will also provide at page 104. Rather, 103 itself as rather 9. This case involves serious disputed question of fact. The witness may be having some bona fide difficulties in obtaining and pursuing the certificate. The claim that the witness was registered as an occupant of the land is the dates of 1968. Only because the witness are not reviewing the original special technique. It cannot be said that the witness was not registered occupant in respect of the land person. The endorsement dated 11/6/1968 annexure C prima facie indicates the land in question along with 3 other items of land was granted to possession. The including order states that the claim made in respect of lands at 7 number 101 in form number 8 was rejected. The special deputy finds that environmental source by virtue of this signature is named become regular for the first time is not there at all. In view of these assertions and denials, this court is not persuaded to deliver a categorical finding to the petitioner. Necessary that was registered document and considered. The fact called for a fact finding exercise and therefore adjudication and itself. And therefore dispose this petition without expressing any opinion. Substantially or otherwise in order to reserve a liberty to the petitioner to find that newly constituted suit, because constituted suit, the Supreme Court decision anticipated suits as liquidity as possible, which are adjudicate the matter independently and uninfluenced in the present. So, they further go on to say that the sale of the transaction. What are the petition is available to that? Who file a interview, the interview is rejected, file a review before the division bench, the honorable division bench also. The thing is dismissed with the prayer that they will prefer a review between the third even then you pass the order. That also comes to be rejected. The last one is not finally the operating portion of the order at page 120. I think you.
One ನಿಮಿಷ. So the name of the petitioners were entered in the land records. But the special deputy commissioner passed an order on 8/9/2011 directing deletion of the name of the petitioners. That is how you have to approach this court. Yes.
In fact, the MR entries and monies are.
Yes, sir.
Way back of 40 years ago.
Yes.
This matter was already raised arbitration before this one was put. The only matter is the commission is the order is not ready. But this one was put the court and then itself the taken note of the fact that they are not ready. Nonetheless, an endorsement they had produced was subsequent to this order. So this order court was aware of the fact that they are not ready. But still this order court was that I can't conceive it. Court cannot come to a conclusion and relegate them back to the civil court or state their right. But without approaching the civil court as delegated by this.
Why they should go to civil court?
They have waited for 7 years.
So that is why the learned senior counsel wanted to place reliance on a decision of mine, which was passed earlier. That these kind of orders or proceedings that are taken up by the deputy commissioners or the assistant commissioners, invoking the suo motu powers under section 136(3), even if it is a case of a fraudulent claim and entries are made in the land records, it should be done within reasonable time. Now, the only reason why those orders were passed was they were not able to produce the document. That was also a supporting document.
Just a paper. The indicator of the fact is Machada is real ground, in the very same setting. In the real ground, how the actual place is.
But bad as something personal. Taking advantage of the fact that this order.
Adalla, see, all that thing, all that cannot be gone into now in this writ petition. Their claim is based on certain registered documents, and their name had to continue in the land record. That is all. We will not permit the deputy commissioners to tinker with the land records like this. Perfect. That a grant was made in favor of Krishna Shetty. Then?
Thereafter, I have to. 11th March 1958, Krishna Shetty purchases the job.
11th June.
11th March 19, Annexure B, page 36. Right copy.
Allah, if you have narrated it in the memorandum of writ petition, please show that. Para 3, yes.
It's 7.
Ah.
One Mr. Krishna Shetty was the original owner of the said lands, and his ownership and occupancy of the said lands is confirmed by an order of special district dated 25/1968. The order being not being challenged over and become final. Certified copy of the order is issued. Copy of the endorsement document depicting the name of Krishna Shetty as a registered occupant in survey number under section 9 of the Mysore Preservation State is issued by the special disease producer. The petitioner retained the original endorsement and believed before permission. It will be relevant to note that in fact the lands were purchased by Krishna Shetty under a state date 11/3/1938, and thereafter Krishna Shetty filed an application for re-grant in terms of Mysore Preservation State of the North, where the said lands was re-granted as previously stated. Apart from survey number 112, the said Krishna Shetty was registered as an occupant in relation to other lands, that is survey numbers 113, 158, and 169 in Haro Captain Agri village under the order of re-grant dated 23/5/68, which was purchased under the same date dated 1968. Copy of the same deed is then Krishna Shetty sold the said lands to Gopal Selva while the registered sale deed dated 24/7/1968. Copy of the same deed dated 24/7/68 is produced as an extra. Copy of MR 12 of 1981-82 reflecting the transaction is produced as an extra. Gopal H. Wadhwa sold 3 acres to the said lands to Allegola, is the husband, first petition, father of second petition, and 3 acres 8 would asset land to petitioner number 2, which petition. Here is petition number 1, not petition number 2. Right? To the registered sale deed dated 9/7/2004. Copies of the sale deeds are produced at annexation G1 basis. The incumbent center effect job was produced. Pursuant to the sale deed dated 9/7, the petitions have been lawful position of 6 acres 13 acres. The record of rights reflecting the order of the special DC for land dated 23/5/1968 and MR 12 of 81-82 is produced at annexation J. The village map of Harohalli village is produced at annexation J. RPC for the said land showing the names of Krishna Shetty and Gopal H. Wadhwa is produced at annexation L. While this is the factual position, and before the names of Allegoda and petition number 1 details, the respondent number 2 initiated proceedings under 136 regarding the so-called correctness of the entries in relation to said land. The basis of the said inquiry is said to be the report of respondent number 2 dated 29/3/2007, bearing number so, where the Tahsildar has opined that the said land is classified as Nala, that Harakatpalli village is Jolina, that the said land has not been granted to anyone, that the RTC entry showed the land as Sattari Nala for 1981. While from 81, the names of Krishna Shetty and Gopal Wadhwa is depicted as per MR 12/82. That verification has shown there is no MR 12/82 and that request to the proceedings should be initiated in the month. The petitions were not made parties to the said proceeding, despite their names appearing in the income. Subsequently, petitions included themselves as parties, and the petition filed detailed objections bringing forth all the aforementioned facts. Objections filed are produced at the next day. It is relevant to note that during the inquiry, despite her best effort, Allegoda and petitioner did not have the certified copy of the order of the special DC dated 23/5 so in case number so there is annex B and the original of the endorsement annex C. The petitioner therefore produced only a photocopy of the endorsement dated 11/6/2008. The petition respondent number 2, however, rejected the contention advanced by the petitioner and consequently directed the respondent to delete the names of Krishna Shetty Gopal Wadhwa and to show that they are nameless in all of this. Allegoda and petitioner being directly affected by the said order, questioned the before the honorable High Court in WP number so of 2011. The same came to discuss by the honorable court on review of the assertions and denies this honorable court gave finding that the petitioner to this is entitled was a registered document or not, and the matter called for adjudication then the court. Copy of the orders dated from the WP number from this place. Written appeal in
All right. Perfect. This is second round of litigation at the hands of petitioner number 1. So earlier, the first petitioner, along with her father, along with the husband, Sri Allegowda, had filed writ petition number 39393-39394 of 2011, calling in question an order passed by the Special Deputy Commissioner, Bangalore Urban District, in proceedings initiated under Section 136(3) of the Karnataka Land Revenue Act of 1964 in RRT 2 NCR 5/2007-2008, dated 8/9/2011. Stop. Next para. A brief background is necessary to be stated to understand as to why this second round of litigation at the hands of the petitioners. Stop. It is the contention of the petitioners that one Sri Krishnaya Shetty had purchased the estate extent of which he had purchased 9 acres and 28 guntas of land in survey number 112 of Haro Kyatnahalli, Dasanpura Hubli, Bangalore North Taluk, under registered sale deed dated 11/3/1968. Stop. However, Sri Krishnaya Shetty filed an application under the provisions of the Mysore Personal and Miscellaneous Clause Inams Abolition Act of 1958, seeking a regrant of the very same land. Stop. Along with the other lands such as survey number 113, 158 and 159 of Haro Kyatnalli village. Stop. It is contended that the Special Deputy Commissioner for Inams Abolition passed an order in favor of Sri Krishnaya Shetty in case number 169 of 1968-69, dated 23/5/1968, regranting the said lands, including 9 acres and 28 guntas of land in survey number 112, which is the subject matter of this litigation. Full stop. It is contended that Sri Krishnaya Shetty sold the land in question in favor of One Gopal Das H. Wadhwa under a registered sale deed dated 24th of July 1968. Stop. Shri Gopal Das H. Wadhwa sold 3 acres and 22 guntas of land in favor of Shri Allegowda, the husband of the first petitioner herein, and the remaining extent of 3 acres and 8 guntas in favor of Shri Allegowda's wife, who is none other than petitioner number 1 herein. Stop. The two sale deeds were dated 9th of July 2004. Stop. It is contended. Huh? It is contended that the names of the previous vendors, namely Shri Krishna Shetty and thereafter Gopal Das H. Wadhwa, were entered in the land records. So, however, even before the subsequent purchasers could get their name entered in the land records, proceedings were initiated by the Special Deputy Commissioner at the instance of a report submitted from Bangalore North Taluk.
Even before the subsequent purchases could get their name entered in the land records, proceedings were initiated by the special DC at the instance of report submitted by the Tahsildar Bangalore North.
With a letter dated 29/3/2007 that survey number 112 was classified as Nala and therefore it could not have been granted to any person. Full stop. The Special Deputy Commissioner initiated the proceedings in RRT 2 NCR 5 of 2007-2008, invoking the suo motu powers conferred in section 136(3) of the Karnataka Land Revenue Act of 1964. Full stop. The Special Deputy Commissioner it is contended that the subsequent purchasers, Allegowda and Srimati Nagaratnamma, were not made parties to the proceedings. So, the said purchasers impeded themselves subsequently, and in spite of their producing all the relevant records and information, the Special Deputy Commissioner proceeded to pass an order on 8/9/2011 directing the Tahsildar to delete the names of Gopal Das Wadhwana, the name of the then Khatedar Gopal Das H. Wadhwa from the land records in respect of survey number 112, measuring 9 acres and 28 guntas. Full stop. Next para, feeling aggrieved, Shri Allegowda and the first petitioner herein filed the said writ petition before this court, calling in question the orders passed by the Special Deputy Commissioner. Stop. This court, by order dated 29th of November 2012, held that although the petitioners have produced a copy of endorsement dated 11/6/1968, which would prima facie indicate that the lands were granted in favor of Sri Krishna Shetty by the Special Deputy Commissioner for Inams abolition, nevertheless, the petitioners were not able to produce the said orders passed by the Special Deputy Commissioner for Inams abolition. So, moreover, this court was not persuaded to deliver a categorical finding that the petitioners' predecessors in title were the registered occupants under the said act. Stop. It was held that the matter requires fact-finding exercise, which could be undertaken only by a competent civil court. Stop. Accordingly, the writ petition was dismissed without expressing any opinion on the sustainability or otherwise of the impugned order passed by the Special Deputy Commissioner. Stop. The writ appeal filed by the writ petitioners in WA number 564 of 2013 was dismissed by order dated 4th of August 2014, and the review petition in RP number 1047 of 2014 was also dismissed on 25th of September 2014. Stop. Next paragraph. Learned Senior Counsel Shri K. Suman, appearing on behalf of the petitioners, would submit that in the memorandum of writ petition, all these information has been provided. Full stop. However, most importantly, it is submitted that on 8th of June 2019, the petitioners were able to obtain a certified copy of the order dated 23rd of May 1968, passed by the Special Deputy Commissioner for Inams abolition in case number 169 of 1968-69. Stop. In fact, it is submitted that the certified copy has been issued from the office of the second respondent, Special Deputy Commissioner, Bangalore Urban District. Stop. Having been strengthened by the receipt of the certified copy, the petitioners are before this court once again contesting the impugned order passed by the Special Deputy Commissioner in the proceedings in RRT number so and so 5 of 2007-2008. Stop. Next para. During the course of these proceedings, the learned additional advocate general appearing on behalf of the state and the special deputy commissioner vehemently contended that a plain reading of a plain perusal or the certified copy of the order dated 23/5/1968 shows that there is a change of the ink in which the order is written in at least 2 places, and therefore the genuinity of the order is in question. Also, this court, on perusing the certified copy ನಾ ನೀವು ಇದನ್ನ ತಂದಿದ್ರಾ?
You produce the original also.
Ah.
Original is.
Ah.
Ask it to clear.
In fact, the learned additional advocate general had produced the original of the said order, which was maintained in the office of the second respondent special deputy commissioner. Also, on perusal of the order, although this court found that in 2 places there was change of ink in which the order was written by hand, nevertheless, in the considered opinion of this court, it did not make any material difference, since the change in the ink does not indicate that the order was tampered or that it would substantially alter the opinion of the special deputy commissioner. So, most importantly, when the document is maintained in the office of the special deputy commissioner, it cannot be contended at the hands of the special deputy commissioner that the document may not be genuine. Stop. The special deputy commissioner is stopped from making such a contention. Full stop. Next para. Be that as it may, it was also sought to be contended at the hands of the learned additional advocate general that the Tahsildar had rightly brought to the notice of the special deputy commissioner that survey number 112 of Harokyathanahalli was marked as Nala in the village map, and therefore the said land could not have been granted in favor of any person. Stop. Next para. This contention on the part of the respondent authorities also cannot be accepted. Stop. If for any reason it is the opinion of the special deputy commissioner or the state that since survey number 112 was a Nala which could not have been granted in favor of any person, then the state was required to challenge the orders of the special deputy commissioner who had passed the order of regrant under the provisions of the Act, 1954. Stop. It is not within the jurisdiction of the Special Deputy Commissioner invoking Section 136, bracket 3 of the Karnataka Land Revenue Act, 1964 to set aside an order that was passed by the Special Deputy Commissioner under the provisions of the Act, 1954. Stop. Without the orders of the Special Deputy Commissioner passed under the provisions of the Act, 1954 being challenged in a manner known to law and getting it set aside, it was impermissible for the Special Deputy Commissioner to order deletion of the names of the grantee from the land records. Stop. Next para. In that view of the matter, this court is of the considered opinion that the Special Deputy Commissioner could not have initiated the proceedings under Section 136, bracket 3 of the Act, 1964, and he could not have directed deletion of the names of the grantees or the subsequent purchasers from the land records, without getting the original order passed under the Act 1954 set aside in a manner known to law. Full stop. Moreover, as rightly pointed out by the learned senior counsel appearing for the petitioners, this court
The state that annexation is dated 24th of July, which is subsequent to that, after the order.
Allala. Krishna Shetty had in fact purchased the property earlier, but since the provisions would be invoked, he went again before the Special Deputy Commissioner for Inams, seeking re-grant of the same order, same lands, which he had in fact purchased. Yes. ಏನ್ ಹೇಳ್ದೆ?
Considered by senior counsel appearing in this court.
This court, in at least 2 cases, namely in at least 3 cases, namely Srimati Pyari Ma and others versus State of Karnataka and others in WP number 22426 of 2021, semicolon, Srimati S. Nagalakshmi versus the Deputy Commissioner and others in WP number 56799 of 2018, dated 14th of January 2022, and in the case of Srimati N. Revati and others versus the Assistant Commissioner, Bangalore South Subdivision and another and connected matters, by order dated 7/2/2022 has held
Para 7 in Priyama, Para 7.
that even where limitation is not prescribed and suo motu powers are invoked for setting aside an order, the same should be done within reasonable time. Stop. This court had noticed the judgments of the Honorable Supreme Court in the case of Muhammad Kavi Muhammad Amin versus Fatima B. Ibrahim, bracket 1997, close 6 SCC 71, and Joint Collector, Rangareddy District versus D. Narasimha Rao and others, bracket 2015, close 3 SCC 695. I came to a conclusion that even if the title is sought to be disputed on the ground that fraud was played by the grantee while obtaining an order of grant, even then such an order has to be challenged and got cancelled within reasonable time. Full stop. Such is not the case on that comes forth in the present context. Full stop. The only ground on which the Special Deputy Commissioner sought to delete the names of the grantee and the subsequent purchaser from the land records is that a certified copy of the orders were not produced by the petitioners herein. Full stop. Next para. For the reasons stated above, this court is of the considered opinion that the Special Deputy Commissioner could not have invoked the suo motu powers conferred under section 136 bracket 3 of the Act to set at naught the revenue entries made in favor of the original grantee and the subsequent purchasers. Stop. Next para. Accordingly, the writ petition is allowed while setting aside the impugned order dated 8/9/2011 passed by the Special Deputy Commissioner, Bangalore Urban District in proceedings bearing number RRT 2 NCR 5 of 2007-2008. Full stop. Next para. The petitioners are permitted to file necessary application to have their names entered in the land records on the strength of the sale deeds. Stop. If such application is filed by the petitioners, the concerned authority, namely the Tahsildar, shall consider the same and pass necessary orders for entering the names of the purchasers under the registered sale deeds. Stop. Ordered accordingly. Next para. The original records furnished by the learned Additional Advocate General is returned to the learned Additional Advocate General. What put? Number 42. Although it seems you have to pay a certain fee. We will direct you to pay it. You please go and pay it with the registry, and they will upload it and they will secure the issue register. ಆಯ್ತು ಇವಾಗ ಟೈಮ್ ಇಲ್ಲ We'll have it day after tomorrow then. Huh? ತೊಂದ್ರೆ ಇಲ್ಲ. He has got it and you will have it tomorrow otherwise. ಹಿಂಗೆ ತರ್ಸ್ಕೊಂಡಿದ್ದೀರಲ್ಲ, you keep it with you, we will call it tomorrow. Release this matter tomorrow. And you please mention, if it doesn't reach in the morning session, at 2:30 you mention, we will take it up. All other matters next week. Date ಕೊಡೋದಿಲ್ಲ ಯಾವುದು, next week ಬರುತ್ತೆ. We have told them all that matters that do not reach will be listed next week.
ಇಲ್ಲ ಅವರಲ್ಲಿ ಪತ್ರಗಳು ಕುಳಿತಾ ಇದ್ರು. ಯಾರು?
ಬಂದ್ರು.